hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Fellow justices, staff of the Appeals Court, counsel in this morning's cases, and other guests. It is our great pleasure this morning to welcome the newest member of the Appeals Court, Associate Justice Marguerite T. Grant, who was sworn in just yesterday following her confirmation on Wednesday by the Governor's Council. In addition to the other justices of the Appeals Court in attendance on this Zoom, I want to welcome the many Appeals Court staff and retired justices and other distinguished guests, including Norfolk District Attorney Michael Morrissey, members of the Judicial Nominating Commission, Governor's counselors, and many others who join in witnessing these proceedings on our YouTube live stream. And I especially want to welcome Justice Grant's husband, Vincent Costello, and their daughter, Helena Costello, whose pride in Justice Grant today is even greater than ours. Joining me on the virtual bench for the arguments today, in addition to Justice Grant, are Justices Ariane Vuono, Gregory Massing, and Sabita Singh. By tradition, the Appeals Court employs an expanded panel of 5 judges for the first case heard by a newly appointed member of the court. For the remaining cases today, a 3-judge panel will sit consisting of Justices Massing, Singh, and Grant, with a panel change for the last case on the list. Though our expanded panel this morning follows Appeals Court tradition, even the most casual glance reveals that today's ceremony is not bathed in hidebound tradition. This is, in fact, the first ever virtual induction ceremony in the nearly 50-year history of the Appeals Court. Our ability to conduct such a proceeding, and for that matter, to conduct our regular oral arguments, is the product of a great deal of very hard and creative work by teams led by our clerk, Joe Stanton, and our deputy CIO, now acting CIO for the judicial branch, Jeff Travers, at the onset of this pandemic. Their work has made it possible for all judges and staff of the Appeals Court to continue full operations and for our litigants to be heard at argument without exposing themselves or their families to risk of contagion. But Justice Grant brings a first of another sort in a way that augments our tradition. Her arrival marks the first time that a justice bears the same surname as a former Appeals Court justice. The late Justice Donald Grant, no relation, was one of the original 6 justices appointed to the court when it was established in 1972, and was instrumental in establishing many of the operating practices and procedures that continue to this day. In addition, because she was confirmed only 2 days ago, Justice Grant hasn't even had time to purchase her own work uniform. She joins us on the bench today wearing a robe borrowed from another of our former justices, the legendary Rudy Cass. So we have something old, something new, and something borrowed. I suppose we're missing something blue, but once we begin argument in the first case, the virtual timer should close that gap. Justice Marguerite Grant was born in Boston, grew up in Dedham, and now resides in Westwood with her family. She graduated cum laude from Wellesley College in 1983 with a Bachelor of Arts in History and Latin, and then went on to earn her Juris Doctor from Stanford Law School, where she served as managing editor of the Law Review. There are those who say that Stanford is the Harvard of the West, but I think that greatly misses the mark. The first time I visited the Stanford campus several years after I began my legal career, I wondered what in the world I was doing in Boston. So it is testament to Justice Grant's loyalty that she returned to Massachusetts after spending 3 years in the sunshine of Palo Alto with the eucalyptus trees in the paradise that is the Stanford campus. We are grateful that she did. After her graduation from law school, Justice Grant began her career with the Boston law firm of Hill & Barlow, where her practice focused on civil litigation. In 1991, Justice Grant joined the Middlesex County District Attorney's Office, where she served as an assistant district attorney for 20 years, principally handling appeals. In 2011, she moved to the Norfolk County District Attorney's Office as an assistant district attorney before her promotion in 2014 to her most recent role as general counsel and director of training. In that capacity, Justice Grant advised the district attorney and trained prosecutors on legal and ethical obligations and argued homicide and sexual assault cases in state appellate courts. In addition to her work as an ADA, Justice Grant served as a lecturer in legal writing for the Harvard Extension School from 1992 to 1997 and is an adjunct professor in appellate advocacy for Northeastern University School of Law from 2002 to 2005. She currently serves as an adjunct professor in professional responsibility at Suffolk University Law School. Justice Grant has been a member of the Board of Trustees of the Massachusetts Bar Foundation since 2007 and was previously a member of the Board of Bar Overseers, serving as its chair from 2007 to 2008. She has served on the Board of Editors of Massachusetts Lawyers Weekly since 2016. She has been a member of the Supreme Judicial Court Standing Advisory Committee on Massachusetts Rules of Criminal Procedure since 2019 and was named one of the top women of law by Mass Lawyers Weekly in 2019. All in all, quite an extensive and distinguished record of public service and accomplishment. Here at the Appeals Court, we follow the custom used in the Superior Court of numbering our judicial seats in the order they were created. Justice Grant is the seventh person to occupy seat number 4, one of the original 6, and most recently held by Justice Sidney Hanlon. Previous occupants include Justices Reuben Goodman, Joseph Warner, Gerald Gillerman, Nick Flannery, and Andre Gelinas. As I am fond of saying, each of us at the Appeals Court stands on the shoulders of giants, and we pay them respect every day by carrying on their legacy of excellence. I should also note that counting all statutory and recall justices, Justice Grant is the 75th person to serve as a justice of this court. I will now ask the clerk of the Appeals Court, Joseph Stanton, to read Justice Grant's judicial commission.
To all to whom these presents shall come, greeting. Know ye that we, by our governor, with the advice and consent of our council, confiding in the ability, discretion, and integrity of Marguerite T. Grant of Westwood, do hereby, under the provisions of Chapter 211A of the General Laws, as most recently amended, and in conformity with our Constitution, constitute and appoint her to be one of the Associate Justices of the Appeals Court, to hold said trust during her good behavior therein, unless removed therefrom in the manner provided by our Constitution. And we do authorize and enjoin her, the said Marguerite T. Grant, to execute and perform all the duties, and she is invested with all the powers and responsibilities which, by our Constitution and laws, do or may pertain to the said office, so long as she shall hold the same by virtue of these presents. Witness His Excellency Charles D. Baker, our governor, and our great seal hereunto affixed at Boston this 15th day of October in the year of our Lord 2020, and of the independence of the United States 244.
It is an honor and a privilege to welcome Justice Marguerite T. Grant to the Massachusetts Appeals Court, and I now invite the justices to join me in welcoming our new colleague. And for the record, I will note that the volume of that applause was muted slightly because so many of our colleagues were on mute during the time, but that does not diminish in any respect our delight in having you join us.
Thank you. It's good to be here.
All right. Now with that, we will say goodbye to the associate justices who are not sitting on panel, and invite the attorneys advocating for the first case in from the waiting room, and we'll just wait a few minutes while our clerk takes care of that. Thank you all.
We are live and on the record.
Good morning and welcome to the Appeals Court again. As indicated during the induction ceremony that preceded this argument, we sit by tradition with an expanded panel for the first sitting of our new Justice of the Court. In this case, our newest Justice is Marguerite Grant. And again, for the record, I welcome her along with my colleagues to the Appeals Court. The first case on our list for hearing this morning is case number 2019 P872, the Commonwealth versus Kenneth M. CHIAPULIS. You may begin your argument.
Okay, thank you. John Hawes for Mr. CHIAPULIS. The defendant here is asking the court to either to dismiss the complaint or to overturn, to remand the matter for a new trial. He's asking this, there are three bases for his request. Two of the bases focus on the issue of public way and impairment, and the third issue centers on the officer's testimony at trial that Mr. CHIAPULIS was impaired while he was operating the motor vehicle in the school parking lot. The first of these issues centers on whether Mr. CHIAPULIS was in fact impaired when he arguably drove on Pleasant Street, which is the only access to the Pleasant Street school. Officer Marin, she encountered the defendant at approximately 8 a.m. At that time, she saw the vehicle parked in the rear lot of the school. There was no recipient witness evidence that Mr. CHIAPULIS had been driving on Pleasant Street. Officer Marin never saw his car in motion. The evidence relating to whether he had been on Pleasant Street was circumstantial in that he would have had to have used that street to gain access to the school. The evidence was that there was no rear egress from the school, that it was a wooded area. On that issue, there was a statement by Mr. CHIAPULIS when asked by Officer Marin where he had been coming from. His statement was to the effect that he had just dropped his car off. I think that that's really the only evidence that places him on Pleasant Street, proximate to the time that Officer Marin encountered him. I would suggest to the court.
Mr. House, you're familiar with the case of Commonwealth versus Bellevue that the Commonwealth cites in its case. It involved a wharf in Charlestown, and the same question arose about there was some question, as there is in this case, whether the public property where the vehicle is located is a public way. But for purposes of this question, I'll engage in the way that you presented the case on the question whether Pleasant Street, the only means of access to the town lot, was a public way. Under Lattimore, it's a fair inference, isn't it, that a vehicle would have had to travel across Pleasant Street in order to reach that location?
Yes, my argument isn't that Pleasant Street is not a public way. The argument is that the only evidence of that he may have been impaired was his statement that he had recently dropped his car off.
Well, no. I mean, you also don't challenge the reasonableness of the inference that he was the person who operated on Pleasant Street to get to the town lot, correct?
I don't challenge that, assuming that he did.
So the question then becomes whether it is a fair inference that he was impaired at the time that he traveled across Pleasant Street to reach the town lot.
And I'm saying that there isn't any evidence to support that conclusion for two reasons. One is that there was no recipient witness evidence. Officer Marin never saw him operating on Pleasant Street. And the only other evidence that he may have been recently on Pleasant Street was his own statement that he dropped his car off.
No, but the car had to traverse Pleasant Street to get there, and he is the only visible operator for the car. I mean, I suppose there's a question of what evidence supports the inference that he was intoxicated at that time. But on that score, we've got two, it seems to me, independent pieces of evidence. We've got his statement saying that all of the alcohol he consumed was from the night before, which a jury is free to credit. And we've also got the absence of any alcoholic beverages or containers in the vehicle or its immediate vicinity at the time he was discovered passed out with the engine running.
Well, I would suggest that there's an absence of evidence. It's simply not in the record. I don't think the issue is dispositive in the sense that when he did awaken in response to Officer Marin pounding on the vehicle, he didn't know where he was. He was mistaken about his location. He reiterated that he was in, I believe, Oxford when he was in Spencer. I think he referred to Oxford and North Oxford. So while there may be a concession that Pleasant Street is a public way and that he would necessarily have had to have driven on Pleasant Street to get to the school property, there was absolutely no evidence as to when he arrived. And while he stated that the alcohol was from the evening before, there is no evidence that that alcohol was consumed prior to his arriving. And while there may not have been any evidence of containers in the vehicle, I would suggest that that's not necessarily dispositive.
Can I, Mr. House,
Counselor, let me ask you, I'm sorry. What do
maybe
you
this is,
think?
what can we say about the fact that the car was not only running and the radio was on, but the car was actually in drive and not in park at the time that the officer arrived at the scene by 8 o'clock in the morning? Could the jury reasonably infer that there had been a recent arrival of the car as a result?
Well, I would suggest the evidence really is to the contrary. He was asleep and likely had been for some time. The radio was blaring. There was a covering of snow on the rear window. The car was in mud up to its rims, I believe was the testimony. And Officer Marin testified that she had to park quite some distance away and walk through thick, deep mud in order to get to his car. I would suggest that given the covering of snow and the topography, namely the mud, that it would have been difficult for him to have gotten to the resting place of the car had he tried to drive into that location in recent to the time that Officer Marin arrived. What I'm suggesting is that when he drove in there, it was not muddy. There was no evidence of tracks leading to the area. I think there really is no evidence as to when he arrived. And in fact, the evidence really suggests the contrary, that he had been there for quite some time.
But
I have a
aren't you also, oh, go ahead, Mark.
I have a question about the public way issue about the school parking lot. I understand that Officer Marin testified that because it was a construction site, the general public would have no reason to be there. What if you had a school parking lot where you had a driveway that was posted, school buses only, no entry from 2 to 3 p.m.? Would that not become not a public way? And if so, would it be not a public way just for that hour? Or would it be not a public way at all in a public school parking lot?
Well, in this case, there were no signs. I'm not familiar with a case that responds directly to your hypothetical situation. Officer Marin did specifically say that the school was not considered public and that the public had no legitimate reason to be there. This was, after all, a school that had been closed for some 20 years, and the last decidedly public purpose was as a school approximately 20 years prior. The only use that the evidence suggested was as a firefighting training center, which apparently had been terminated sometime prior to that when the school became unstable. Since that time, I believe the only use was as a construction zone / staging area for a local public works project. And what she said was that while the crew was a member of the public, the general public had no reason to be there. It was used as a storage facility for equipment. There was extra dirt. I would suggest that the Richards case suggests that there are a number of indicia as to what may be public. That was a case that just addressed whether a defendant who was charged with operating under the influence where he was parked in the front of the school was a public way. In that particular case, the court did not decide that the mere fact that it was a school classified or qualified it as a public way. They cited various indicia which are not present in this case. There were no traffic signals, there were no abutters, there were no residential abutters, there were no business abutters. Officer Marin testified that there was no parking for local businesses. In addition, unlike the Richards case, there was no janitor present, there were no lights that were on. There was no egress in the Richards case. There were
Well, so I guess, does the officer's testimony that in her opinion, the general public would have no reason to be there preclude members of the public from being licensees or invitees within the meaning of the public way statute?
Well, I think that on the whole, the law is that it's a case-by-case analysis, and it's based on the status of the way. So it's not the status of the driver and what the driver may reasonably believe to be true relative to whether access is open to invitees or licensees. So in this case, there really is no indicia that this property would be open to public use. Unlike the Richards case, where there were abutters who used a rear egress to access their own private residences and driveway, there's simply nothing here. This is simply a school that was on a main street that apparently has nothing surrounding it that indicates that there's any use beyond a parking lot for a school, which was clearly defunct. While there was no signage that the trespassing wasn't allowed or it was fenced off, there was clearly no reason to think that it was open for public travel through the lot of the school. It was clearly a construction zone. The rear topography of the school was clearly mud, no access. I would suggest that there. Oh, I'm sorry.
I think Justice Massing has a question for you.
Yeah, I do have a question. Your contention with respect to the street is that we can concede at some point he drove on Pleasant Street before he got there, but there's no evidence that he was intoxicated at that point. With respect to the parking lot, isn't it, even if that's not, I mean, if that even that is a public way, isn't your argument the same? Would you say that there's more evidence that he drove in the parking lot than he did on the street, or is it the same? You can't infer that he even drove drunk in the parking lot.
Well, I think that the elements of operation here, the evidence would be that the engine was running according to the officer's testimony. There was a plume of smoke that was coming out of the exhaust. The car was in drive, and I believe that that it was running. So I think that would satisfy the element of operation. What I'm saying, I think, with respect.
Okay, so wait. So how far is it from the street to where he was parked?
I don't know what the distance was, but I know that the evidence is that the parking lot was in the rear of the school, so that he had to. So the only access is from Pleasant Street, which is in the front of the school. It butts the front boundary of the property.
So what you're saying somehow, like, he wasn't drunk when he was driving on Pleasant Street, but somehow he got drunk in the parking lot.
I'm saying that there is no evidence that when he drove on Pleasant Street that he was impaired.
Oh, no, but Justice Massey's question, because I've been puzzling the same question myself. He clearly was impaired. He clearly was drunk when he was discovered passed out in the driver's seat.
That is correct. I would concede.
Okay. And he drove at some previous time, we don't know when, on Pleasant Street to get to that location, right?
That is correct.
So in order for you to negate the idea, the premise that he was impaired while he was on Pleasant Street, you need to urge us to conclude that the evidence supports the possibility that he became drunk while he was in the parking lot.
Well, I would say on the positive side of that, there simply is no evidence that he was impaired while he was on. I would suggest that it boils down to two things. There was no recipient witness evidence that he was observed on Pleasant Street while impaired. And it seems to me that the argument is essentially, since there were no containers of alcohol in the car, he therefore must have been impaired when he drove on.
But you cannot become drunk without consuming alcohol. There was evidence. You characterized or dismissed the suggestion earlier by saying it's simply the absence of evidence. But there is nothing to provide any support for the possibility that he became impaired while he was in the parking lot. Is there?
Well, I think it's ultimately all conjecture. What's clear is that he was clearly arguing, assuming that he was clearly impaired when Officer Marin arrived. What I'm suggesting is there is nothing in the record evidence to say that he arrived in that state. And so that with respect to Pleasant Street, insofar as it qualifies as a public way, there's no evidence that he was impaired when he drove on. It simply isn't there. I mean, there may be an inference and there may be speculation that he was impaired, but the record evidence doesn't support that. I'm sorry?
His statement that all of the alcohol he consumed the night before.
I would suggest that the evidence is not clear on that particular matter.
Isn't that for the jury to decide?
And that he just dropped off his vehicle. The word just means that he recently arrived there.
Well, I'm suggesting in my brief that when he awoke, he was disoriented. He did not know where he was. He suggested that he was either in Oxford or North Oxford when Officer Marin told him that he was in Spencer. I'm suggesting that, and I believe she checked for his license and registration, found he was validly licensed and the car was registered. There was no evidence that it was registered to another. So what I'm suggesting is that when he stated that he had just dropped his car off, it was a meager excuse to provide some, albeit I'm not sure what the explanation would have been, but I wouldn't take his, I think I'm saying that his statement that he just dropped his car off just simply isn't reliable.
Okay, I think we'll leave it there. Thank you very much. We'll hear from the Commonwealth.
Thank you.
Good morning, Your Honors. May it please the court, Abigail Solois on behalf of the Commonwealth. May I briefly say, Justice Grant, congratulations. There are two main issues in this case, sufficiency of the evidence and the police officer's testimony regarding the defendant's intoxication. With the court's permission, I'd like to start by addressing sufficiency first, specifically public way. The jury heard enough evidence for it to conclude beyond a reasonable doubt that the defendant was operating under the influence of alcohol on a public way. As such, his conviction should stand. A public way is any place where the public has access to as invitees or licensees. However, one may violate the OUI statute even if his presence on the way is without the benefit of a specific license or invitation. The following indicia of accessibility existed here. First, the property was owned by the town of Spencer. There was no fence, tape, or signage or gate restricting the public's access. And it, at that time, and also in the past, had only been used for municipal use. So it was a school, then it was a fire department, training facility, and at the time of the offense, it was a staging area for the city or the town's construction.
I have a question for you.
Yes.
The public way definition talks about it can either be a way or a place. Does the word way imply that it's a route that's used to get somewhere as opposed to a place? And if so, is this a way?
No, so the legislature actually expanded the statute to include the word place because it used to just say way. So this is a place, and it doesn't matter that it's a, not a highway or a road. Sorry, was there another question that I cut off?
So it wouldn't matter if it's a dead end or a parking lot that doesn't go anywhere?
No, that doesn't matter. So even if the status of the lot as a public way is a close question, for the sake of argument, like in the Bellevue case that was mentioned earlier, this court need not resolve it because the defendant must have traveled on a public way, that being Pleasant Street and Spencer, to access the lot. There was no other way to access it.
Was there evidence of the distance from the entry to the lot to how far he was parking?
There wasn't, Your Honor. Officer Morin didn't observe any empty or full alcohol containers at the scene.
Well, I noticed that you said that in your brief, but there was no transcript site. Did anyone ever ask her if she saw any alcohol containers?
No, there wasn't any evidence of it either way.
So you're essentially asking us to infer from the absence of evidence of whether there were alcohol containers that there were none.
Yes, I mean, I think it would be reasonable to assume perhaps that if there was alcohol containers strewn about the scene, that would have, certainly the Commonwealth would have brought that out in its case.
I don't know.
That your argument rests on negating the presence of alcoholic containers. Isn't it your burden to produce that evidence rather than to rely on the absence?
Sure, of course it's our burden. It's always our burden. So even taking that out of it, the evidence is certainly sufficient, even taking out the absence of alcohol containers. The defendant admitted to consuming alcohol the night before and was discovered relatively early the next morning.
Not that early. I mean, if it was all from the night before, that's 7.5, 8 hours.
Sure. I mean, it was also wintertime. There was snow on the car, so the sun had just come up. When he's saying the night before, we don't know what time he's referring to. The jury could reasonably have inferred that the defendant was intoxicated while he was driving on Pleasant Street. It's certainly well established that inferences drawn from circumstantial evidence need only be reasonable and possible. They don't need to be necessary or inescapable.
The
So if I
officer
may,
not only formed that belief, but offered that opinion. Can you explain to me how it is all these years after Commonwealth versus Canty that police officers still have difficulty avoiding that formulation?
I don't think I can even count how many times I've briefed this issue. The prosecutors in my office have been trained on how to ask the question. Sometimes the answer is not what we hope it to be. And in this case, you know,
You've done a pretty good job of flowing out training on the required elements for a stop and frisk and for other aspects of search and seizure. You know, it's just baffling to me
yes.
that this question persists. And you know, I could have understood it maybe 5-6 years ago, but here we are, 2020. We've got enough on our plates to have to keep batting away this question.
Well,
Yes, I mean, respectfully, Your Honor, the question was fine. It was the officer's answer that was problematic in this case.
But that's an issue. I'm not faulting
Yes.
the prosecutor in the asking of the question. It's a cri de coeur to ask you and your colleagues around the Commonwealth to get the training out there to the officers, because this is this is a conversation we shouldn't be having.
Absolutely, Your Honor. I'm tired of briefing the issue. I'm with you on that.
Despite the issue, there was no objection. Despite the issue being longstanding, well-established, there was no objection, correct?
Yes, the defendant didn't object. The defendant did not ask Judge McCarthy for a curative instruction. And in fact, both parties stated that they were satisfied with Judge McCarthy's jury instructions.
would there be any tactical reason not to object when this is such a clear issue of law since Canty?
I think perhaps there was no objection because, well, no, I can't speak for why there was no objection. However, I can speak to why both parties said they were satisfied with the instructions, because Judge McCarthy provided, she mitigated any risk of undue prejudice to the defendant by providing comprehensive instructions to the jury that it was really up to them to decide the ultimate issue and to weigh credibility of the witnesses, and they were not required to accept the officer's opinion as to the ultimate issue.
Are you aware of any case in the Commonwealth, any appellate case in the Commonwealth, I should say published appellate case, where we have reversed an operating under conviction on an unpreserved Canty error? We are the SJC.
I can't think of one off the top of my head, and the reason being is that usually it's cured by a jury instruction.
Jury instruction, strength of the evidence, some combination of those two. Your brother didn't cite a published case. I was just curious whether there is one out there, whether this exercise, in addition to being unnecessary, is academic.
I'm not aware of one, but that doesn't mean there is not one that exists that I'm not aware of.
Is it
Usually-
more prejudicial to the defendant here that the officer said, in my opinion, he was operating impaired, and it's that word operating that was improper, where the defense here is that the defendant wasn't operating? In other words, if it was solely an intoxication defense or a public way defense, maybe it wouldn't have been as prejudicial, but where the defense is, it's only circumstantial that he was operating on the street, and the officer uses that opinion, throws in that opinion that he was in fact operating, does that make it more prejudicial?
I don't think the defendant is arguing. I think he's conceding operation because as my brother
now he is, but maybe not in front of the jury.
I mean, to me, operation is not and wasn't really a real issue in the case where the defendant's engine was running and the car was in the drive gear. So I think what the real point of contention was at the trial was the public way factor. But yes, of course, Officer Morin can only speak to the defendant's intoxication, not how it affected the defendant's ability to operate the vehicle. And of course, yes, there was also overwhelming evidence of the defendant's guilt in this case, including his own admission to consuming alcohol. And I think
testimony, the opinion testimony, in fairness, did not encompass the element of public way.
No, No, it did not. And going to the overwhelming evidence of intoxication that causes this error not to be prejudicial, the circumstances where the defendant was found, I think someone who had their wits about them and was not intoxicated, if your car was stuck in the mud, you wouldn't be asleep in the car with the engine running and the car in drive. That's just, that goes to his judgment and his ability to operate his car safely. So I think the evidence was overwhelming in this case. And I'd like to conclude if there's no other questions from the panel. Okay, seeing there's no other questions, the Commonwealth respectfully asks this court to affirm the defendant's convictions where the jury heard ample circumstantial evidence, along with reasonable inferences therefrom, to conclude that the defendant operated his vehicle while intoxicated on a public way. And Judge McCarthy's jury instruction mitigated any risk of undue prejudice to the defendant stemming from the police officer's testimony. Thank you, Your Honors.
Thank you. Thank you both. We will return to the waiting room, and that concludes the argument in this case. This case is submitted.
We are live and on the record.
Thank you. Good morning and welcome to the Massachusetts Appeals Court oral argument session for October 16, 2020. As you know, this argument is being held on Zoom and live streamed on the Appeals Court YouTube channel, but we follow the same rules as customs as in the physical courtroom, except you may remain seated while you're speaking. Once we get going, the session clerk will display a countdown clock. Each side has 15 minutes to argue. There's no rebuttal. Only one advocate may speak at a time, and the clerk will mute the other advocates until it is your turn to speak. But we can still see you, so please keep your reactions and gesticulations to a minimum. The proceeding is being recorded and archived, so it will be available to the public even after this is over. And with that, as always, we've read your briefs and we're familiar with the case. Although you have 15 minutes, we won't hold it against you if you stop early. And with that, I'll call case number 2 today, which is Commonwealth versus ALEXIS SAEZ, 2018 P1718. And Attorney Horowitz, you have the floor.
May it please the court, Dan Horowitz for Mr. SAEZ. I'm primarily prepared to address the first 2 issues.
I'm sorry, are you folks having trouble hearing him, or is it just me?
Yeah.
A little difficulty.
You're a little,
Okay, is this loud enough?
it's more like it's kind of like,
Garbled.
yes, garbled. I don't know if you can.
Be close to the microphone, I would say. That might help.
Try to move my computer forward. I'm not sure exactly where the microphone is. Is this better?
Well, let's give it a go.
I'm primarily prepared to deal with the first and second issue. The first, I would say, is the most important one. It was admission of evidence that in a Walmart parking lot and inside the Walmart earlier, SAEZ had confronted Elsa Ortiz and Luis Torres. Everything he said, according to them, indicates that he was angry at them. He blamed them for his inability to see his child and what he felt was interference in his relationship with CP, the main victim. Now, this was admitted on a number of grounds, as course of conduct evidence, as evidence of a threat against CP, as consciousness of guilt evidence, and the Commonwealth suggests also to be considered part of the circumstances warranting apprehension on CP's part as to other threats that were made directly to her. So I'd like to take those in turn.
Okay, can I ask you a preliminary question? You have a motion to strike the Commonwealth's references to the victim or alleged victim, whatever you want to call her. And you seem to see like is there an official rule that you have to call them by their initials?
No, it's a convention I've followed and the courts followed in the past. I just thought there was some potential for confusion if each of us are referring to her with a different name.
Okay, I mean, it seems like the Commonwealth made an effort. You know, the CT is sort of an effort to, if you will, distance yourself from the person. The Commonwealth used a name to sort of make it closer. But is it really an issue?
I mean, for purposes of the argument, then.
Okay, so go ahead.
So as to course of conduct and as a threat against CP, I would argue that the black letter law about threat to commit a crime makes clear that this should have been charged as a threat against Elsa Ortiz. I point to something, a case like Commonwealth versus Charlotte. That's where a defendant is bolting at a prosecutor, points at the prosecutor and says, "Watch out, Elsa." In a situation like that, the prosecutor is both the target of the threat and the target of the threatened crime. And in this case, Elsa Ortiz was the target of the threat and the target of the threatened crime.
What if, go ahead.
Oh no, I'm, okay. CT wasn't meant.
Couldn't it have, even if it was a threat to Ortiz, couldn't it have also have been evidence, or couldn't it have also been used to show the reasonable apprehension of fear because of the presence of an actual gun?
On whose part? I want to make clear that threat indictment, the only indictment about a threat is named CT as the victim.
Right, on CT's part, with the fact that that he's threatening her mother with a gun, won't that make, we can presume she talks to her mother, wouldn't that sort of make CT fear more?
Well, as to, I want to clarify the issue, because the Commonwealth appeared to suggest in its brief that the fear is on the part of the other threats that CT testified being made directed to her. And if that's the question, then the answer is no, because even if we assume knowledge, even if we assume Elsa told CT about this, the timing is off. The latest threat, that is the most recent trial that CT testified to specifically, was around August of 2010. It's SAEZ following her to a place of work and confronting her. She specifically stated that after the August 9th, 2010 restraining order, there was nothing much, her words. Pressed further, she said there were some calls she didn't pick up and the voicemail SAEZ left. This Walmart thing happened over in November 2010, months later. And I would suggest that a threat that happens in November can't be considered part of circumstances surrounding any other earlier threats from months prior or years prior, because again, this indictment was a 5.5-year period.
I have a question for you. What if your client had shown the gun, say not to the mother, but to a mutual friend of himself and CT/Jillian, and had just shown the gun and said, "Look at the new gun I got"? Would that evidence be admissible, assuming there was an inference that the mutual friend would communicate it back to Jillian/CT? Would that be admissible to show so there's no threat against anyone? Would that be admissible?
If the timing is the same, I would say no. I think what you need, and I think that Hamilton bears this out, is you need some indication that the defendant is talking about the named victim. So, for example, in Hamilton, the defendant calls his probation officer and insinuates he could get someone to hurt the probation officer's daughter. And the court said, it's okay to name the probation officer as a victim of that. And I'm suggesting the distinction here is he isn't saying anything, either in the hypothetical or in what happened in the trial. SAEZ isn't saying anything about CP or indicating that he's directing a threat at CP. Everything is his anger at Elsa Turkey and by extension, specifically. And again, because according to their own testimony, he said it was about anger that he couldn't see his son.
When your client said, "Look, this is for you," is there possibly an inference that the "you" could be you plural and mean the whole family?
I suggest that would be speculative. I mean, he didn't just say it. According to Elsa Ortiz, he held the gun out. He didn't point it at her, but he displayed it to her. That's my answer. I argue it would be speculative to presume that this meant also for CT, who wasn't present It wasn't mentioned at all for this entire incident.
Just a housekeeping thing. There's a mention in the transcript that there was a motion to exclude this testimony. It was argued overnight. There were emails sent to the judge. Are those emails in the record?
That's a good question. I might have to report back to the court. I don't.
I mean, I don't think they're in the record
I think
appendix.
the judge mentions the cases though in the email, in the course of the sidebar about.
Okay, and so I mean, the judge decided to admit the evidence. Was there a limiting instruction requested?
I don't believe so. I think what happened is the defense counsel acquiesced once the judge made a ruling. This is coming in. That was it, and he acquiesced.
Don't you argue to the contrary of that in your brief? I mean, isn't there a question of whether he the Commonwealth says it was waived because he acquiesced, and don't you say that no, he didn't acquiesce? That was just what you say. You say thank you, Your Honor, when you lose the objection.
Well, yes, or very well. I mean, in each of the cases, well, actually, the point is at least this first that was argued at sidebar over 2 separate days. After a point, further objection is futile. I mean, you can't expect lawyers to keep arguing and arguing and arguing once the judge makes it clear, right? And so the judge said, no, I'm admitting this on these various grounds. So there wasn't any, I would suggest there wasn't, because one of the grounds was on directly as evidence on the threat indictment. There wasn't any basis for defense counsel to ask for a limited instruction.
Can I ask another question? You argue in your brief that we should be looking at this under the harmless beyond a reasonable doubt standard. In the Commonwealth, you shake your head.
There was another motion to strike. I confess, there are some parts that here a number of briefs I accidentally included the constitutional standard in addition to the prejudicial error standard. The first issue, I did cite LL versus Commonwealth. The issue is abuse of discretion and whether it's prejudicial error. As to the first issue, it's more upon the judge.
And then prejudicial error, and it's and the judge has to weigh it for whether it's substantially outweighed or just outweighed. Whether prejudice substantially outweighs or just outweighs the probative value.
Well, I would argue both. This is a far more. This is a threat of murder. I think you read as, and that's a far worse crime than any of the. I don't mean to downplay domestic violence, but it's a far worse crime than any of the charged.
Wasn't there testimony that the threats, in fact, were threats to shoot, right?
Those were earlier threats to shoot. Yes, there were. But that's
so how prejudicial could, I mean, you're saying that this is a threat, sort of a threat of a different kind. It's really of the same nature.
But there's no indication, well, first, there's no indication in the record that he had a gun other than this. A jury could see it as just words and focus on the physical conduct. But once there's evidence of a gun, I think that's a lot weightier. He actually has a weapon.
And doesn't that weigh in favor of the Commonwealth's argument for the relevance of the gun, the presence of an actual gun?
The problem is the presence of a gun is in November of 2010. When he's threatening the shooter, that's earlier in 2010, that's in 2007 or 8. I don't remember the exact date for each of the threats. There are a number of them. But at the time those threats are made, he doesn't have a weapon.
But was there testimony as to CT's knowledge of his presence, of his possession of a gun?
I don't believe so. I don't believe there's any testimony he knew he had a gun or about the threat with Vuono. And again, if he threatens to shoot her in 2007, I don't think we can presume that he had a gun in 2010. In November of 2010, he had it earlier and she knew about it. Absent direct evidence of that.
I have some questions about the sequestration issue.
Yes.
It's sort of a two-part question. Did the judge instruct the jurors that the witnesses were sequestered, and couldn't the jurors see for themselves that Aunt Evelyn was in the courtroom for a period of time? And so if that's the case, how would it be prejudicial to the defendant for them to hear the testimony about how long she was in the courtroom?
The issue is not merely hearing about her being in the courtroom. It is that what happened on voir dire, what the judge found is that she only told defense counsel in the afternoon that she had something to say. And that's why she had actually ended up accidentally in the courtroom. But during her testimony, it sounds like a slip of the tongue. During her testimony, she says she told defense counsel that morning before there was any testimony. And the problem there is there are two sort of conflicting but two possible images this could create for the jury. First, that she told defense counsel and she was alerted to the sequestration order and violated it, or she told defense counsel and defense counsel chose not to alert her. So even if the jurors know there's a sequestration order, that doesn't affect what the image created of whether or not she knew, because whether or not defense counsel told her, or whether defense counsel is still part of this. And I mean, the nub of the argument is the needlessness of the remedy, because once the judge refused to strike testimony of the presence in the courtroom, counsel just asked for a chance to rehabilitate. And it would only have taken a few questions, maybe even one, so that he could clarify that she misspoke when she said she told him, when she testified, that she told him she wanted to testify in the morning, and that actually it was in the afternoon. And that would have solved it. And that's why I'm arguing a prejudicial error, because it seems unreasonable to not let the defense counsel do that, where the questions are not going to bog the jury down, especially, I believe there was, there were 11 volumes of transcripts, 4 of those were days of deliberation, but this was a relatively long trial. A few questions on one day is not going to sidetrack the whole trial.
But the testimony from that witness that was actually in front of the jury, it was sort of a brief exchange where the witness sort of denied everything. So there didn't seem to be really anything that was before the jury. Every question that the prosecutor asked, or that the witness was asked, the witness denied. No, that didn't happen. No. So I'm not sure that there was anything before the jury.
Well, what was before the jury is she was in the courtroom during the testimony. The problem with what was left before the jury is that she had told defense counsel in the morning, when that's not what she said on voir dire, that's not what she found, but that's what the jury ended up with. And I see I am at time.
Yeah, we stopped. We actually took a little while of your time at the beginning because of the audio problem. If you want to sum up in 15 or 30 seconds, go ahead.
Okay, so hopping back to prejudice from this threat, the other problem is there's sort of even though the prosecutor didn't argue this, it bolsters Ortiz's testimony, because the jury, if they believe this threat happened, then they're going to conclude, well, she's testifying even under this sort of standing threat of murder. What she says is probably true, and if they accept that, then they think, well, if SAEZ is a man who, when he's angry, he can go as far as to threaten murder in a Walmart parking lot, then he probably did what CT testified to. Because everything she testified to was something done in anger, whether it's a threat, whether it was violence. It was always in the context of a fight. And I analogize to McClendon.
Okay, I think we got it, and we'll leave it there. Unless there are any other questions from the other justices. Okay, thank you very much, Mr. Horowitz.
Thank you.
And we'll, so Mr. Touchy, I've just started, the clock will start with you.
Thank you, Your Honor. Can the court hear me okay?
Yes.
Thank you, Your Honor. Good morning, Your Honor. May it please the court. My name is Konstantin Tretyakov from the Middlesex County District Attorney's Office. I represent the Commonwealth. With respect to the defendant, to the issue of allowing the victim's mother to testify that the defendant produced a gun to her at the Walmart parking lot and said, look, this is for you, there was no abuse of discretion in that evidentiary ruling, because that evidence was directly relevant to the circumstances in which a reasonable person would apprehend the threat that the defendant was repeatedly making against the victim. The victim
Can you counter your brother's argument regarding the timeline? The threats that are being charged in the case happened much earlier. So how can an incident that happens later really reflect on that?
Yes, Your Honor. As an initial matter, I think it is worthwhile emphasizing that the defendant was indicted for crimes that he was committing against the victim from March 2004 through November 2010. That's 6.5 years of abuse. In this context, the 2-month gap between the threats that he was making towards the victim and the time when he produced the gun to the mother at the parking lot is relatively insignificant. But more important than that, in the seminal case on the threats to commit a crime, which is cited in the Commonwealth's brief, Commonwealth against Shawley, this court observed that these circumstances, that in that case, the defendant was threatening someone in the courthouse, and the defendant's contention was that he could not have done that because there were other people in the courthouse. And this court observed that this does not mean that the defendant could not carry out a threat at a later time. And that language was then cited approvingly in other cases, including, for example, Commonwealth against Milo M. So the relevance here is that the fact that, yes, the defendant did produce the gun approximately 2 months after he threatened the victim, and he specifically threatened to shoot the victim, to hurt the victim's family. He made a gun gesture and say, I'm going to get you. He specifically threatened to shoot out her car windows. That prompted the victim to call the police in the August of 2010 to her apartment. But the 2 months that have passed, the fact that the defendant produced the gun after that period of time, it was directly relevant to the fact that later on he could have, even assuming for the sake of argument that in August he did not have a gun, of which there was no evidence. But that was directly relevant to the fact that later in time he could have followed through on his threats, and that went again directly to the element of reasonable apprehension of circumstances, which is one of the elements of threat to commit a crime. I would also note for the court that the defendant was also charged with stalking in violation of a restraining order. That's count 5 of his indictments. And I would submit to the court that showing the gun to the victim's mother, thereby reasonably causing substantial emotional distress to the victim, would also be relevant as to that charge. I also wanted to touch upon the issue whether—
I'm sorry, but that wasn't argued in your brief, correct?
No, Your Honor. It's just, I did not argue that. This is just a observation that I'm making during the oral argument.
And just again, going back, when you say that on the reasonable apprehension of fear argument, you're saying that, so the question isn't whether she had a reasonable apprehension of fear. It's a question for the jury as to whether one could have a reasonable apprehension of fear, and that's why whether or not she knew about the gun doesn't matter?
Your Honor, in this case, well, the question, the element of the threat to commit a crime as far as reasonable apprehension, I believe the case law states that it is an objective test. It doesn't matter whether the actual person was in fear, it will be whether or not a reasonable person would be in fear. And again, the language in Shawley strongly suggests that in evaluating that claim, the court also takes into consideration whether or not there is evidence that the defendant could have carried a threat at a later time. And the evidence of producing a gun to the mother is directly relevant to that. There was also evidence, just going back to one of the questions that were posed to my brother, that the victim actually knew about the argument and the production of the gun at the parking lot. It can be found on page 65 of volume 6 of the trial transcript, when the father testified that after the incident, he immediately called the daughter, and it was actually the daughter, the victim, who called the police to the parking lot. So given the fact that the admitted evidence was relevant to one of the elements of the crime that the defendant was charged with, and given the fact that it did not substantially outweigh, the probative value of it did not substantially outweigh a risk of unfair prejudice to the defendant, there was no abuse of discretion in the judge's ruling. As to
Mr. Tretyakov, I think you have a footnote in your brief that the substantial doesn't apply, but it does apply, right?
yes, Your Honor, the judge did say that it does not outweigh the unfair prejudice. Thereby, she applied a standard more favorable to the defendant, but the standard is that it's substantial, whether it substantially outweighs.
Actually, wait, I spoke wrong. For prior bad acts, Creighton says the standard is just outweighs. It's for most, the general rule is it substantially outweighs, but for prior bad acts, the Creighton case 470 Mass says it's got to be a substantial. It's got to be it's an easier standard for the defendant.
Yes, I believe so, Your Honor. Unless the court has further questions on this issue, I would like now to turn to the sequestration order. So what happened was that on the third day of trial, defense counsel informed the Commonwealth and the court for the first time that he has learned that the defendant's aunt was going to testify about the incident, the alleged incident during which the victim was supposedly running against the defendant with a pair of scissors in their apartment. And the Commonwealth objected to that proposal because we were concerned that the defendant's aunt was in the courtroom during the time that the victim was testifying. On the sixth day of trial, the judge conducted a voir dire of the aunt to establish whether and what is she going to testify about, and allowed the aunt to testify. So the defendant basically, he obtained the ruling that he wanted from the judge. During the testimony, on direct, the aunt testified about the incident with the scissors, and during the cross-examination, the Commonwealth cross-examined her among other issues on whether or not she was present in the courtroom during the victim's testimony and for how long she was present in here, because as the case law suggests, it is absolutely permissible to cross-examine any witnesses on a violation of the sequestration order.
Did Judge Brieger tell the jury at the beginning of trial that the witnesses were going to be sequestered and what that meant?
I don't believe so, Your Honor. No.
Okay, but they could see who was in the courtroom at various times.
Yes, they could. And during the testimony, during the cross-examination, the aunt made two contradictory statements over the span of 2 pages of the trial transcript. She first told the prosecutor that she did not discuss her testimony with the defense counsel prior to the victim's testimony. And then she said, yes, I did discuss that. So based on those two contradictions, based on that contradiction in her testimony, the Commonwealth moved to strike the entirety of the testimony of the aunt, and the defense counsel moved to withdraw. The trial judge, acted absolutely within her discretion when she said that the precise timing at which the witness discussed her testimony with defense counsel is not relevant to any issue at trial. It was an entirely collateral issue. And then she carefully crafted a remedy in which she said that neither the Commonwealth nor defense counsel will be further exploring the issue of a sequestration order violation by the aunt so that it does not confuse the jury, but the Commonwealth would be able to call a rebuttal witness to testify about the precise amount of time that the aunt spent in the courtroom, because the aunt testified that she was in courtroom for 5 to 10 minutes, and the Commonwealth's victim witness advocate said that it was 45 minutes to an hour.
So the judge was trying to avoid this issue that counsel was concerned about his own credibility, his own ethics being
correct, Your
the
Honor,
center of the focus.
Yes, because the defense counsel says, I now need to rehabilitate my witness, but I can only do that if I'm with the witness on the stand, because only I, in addition to her, can testify when she actually was talking to me. Therefore, I have to withdraw from the case. The judge did not abuse her discretion when she said, this is irrelevant. We will not be touching that at all. And I specifically instruct and preclude the Commonwealth and the defense counsel from exploring this issue any further. So that was the ruling of the trial judge on the sequestration order, which under the case law is generally subject to the abuse of discretion standard. And I would respectfully submit that there was no abuse of discretion here.
Did the rebuttal witness actually appear then?
Yes, Your Honor.
So the victim witness advocate was called?
Yes, the victim witness advocate testified, and also the Commonwealth in our closing argument, we did mention to the jury that the aunt told you that she was in the courtroom for 5 to 10 minutes, whereas the victim witness advocate told the jury that she was in the courtroom for 45 minutes to an hour.
Did the prosecutor mention anything about a violation of a sequestration order in the closing?
I do not believe so, Your Honor. If I could just have a brief moment. I can't recall anything off the top of my head. I do think that there was testimony about, there was closing argument about the aunt's credibility based on the statement that, based on what was elicited on direct and cross-examination, not related to the sequestration order. And then there was also argument that she was in the courtroom not for 5 to 10 minutes, but for 45 minutes. But I do not recall whether the sequestration order was mentioned in the closing argument. And with turning now to, unless the court has further questions, turning now to the third issue that the defendant raises on appeal with respect to the specific names that the victim allegedly called the defendant's girlfriend. That was repetitive and cumulative testimony because the jurors heard those exact same names 4 times prior to the portion of the testimony that was stricken from the record. And the judge also allowed the girlfriend to testify that the victim was insulting her and that she was angry and she was making these potentially threatening gestures towards the girlfriend. So in excluding that cumulative testimony, the judge did not abuse her discretion. Unless the court has, and for all these reasons, the judgment of the Superior Court should be affirmed. Unless the court has further questions, the Commonwealth will rest on its brief.
Seeing none, we thank you very much, both of you. Interesting case. We'll take it under.
We are live and on the record.
Okay. Good morning again, and welcome to the Massachusetts Appeals Court oral argument session for October 16th, 2020. As you know, this argument is being held on Zoom and live streamed on our YouTube channel. Nonetheless, we follow the same rules and customs as in the courtroom, except that you don't have to remain standing while you're arguing. And once we get going, the session clerk will display a countdown clock of 15 minutes. And since there's only one counsel arguing in this case, no brief was filed on the other side. We'll have 15 minutes. After this, the case will be, this recording will stay archived and will be available to the public. So calling the case, it's BW versus SJ, 19P 1802. And Mr. Hahn, you have the floor.
Yes, thank you. Good morning, members of the panel. May it please the court. Attorney Peter Hahn on behalf of the minor defendant SJ on appeal from the issuance of a harassment prevention order out of the Suffolk County Juvenile Court just about 1 year ago in October 2019. I will reference the minor plaintiff and the minor defendant by the initials, BW for the minor plaintiff and SJ for the minor defendant, who I represent. This is about a harassment prevention order case, and we do not believe that there was sufficient credible evidence to meet the standard for issuance of this harassment prevention order in juvenile court, that there were 3 or more instances of conduct, willful and malicious conduct directed at a specific person, where willful and malicious conduct is defined by a motivation of cruelty, hostility, or revenge, and where there was a subjective intent to cause intimidation, fear, abuse, or damage to property. And there was, in fact, the effect of intimidation, fear, abuse, or damage to property. I do want to lay the factual foundation a bit. As a reminder, at the time, on September 17th of 2019, where these allegations arise, BW was a 10-year-old 5th grader and SJ was a 12-year-old 6th grader at a school in a 5th, 6th grade combination class. As it's clear from the record, BW was a student with disabilities with an IEP, and SJ was a student on a 504 seeking an IEP or being evaluated for an IEP at the time. As was clear from the record, SJ was the victim of bullying over years, including an assault that impacted him with a skull fracture, a traumatic brain injury, and resulting PTSD.
Can I just stop you? We are familiar with the record, and
yes,
you know your brief. You do a nice job of painting the evidence in a light most favorable to your client. But when we're reviewing the propriety of this order, don't we have to look to see whether there's any evidence in the record that would support what the judge did?
I'm glad you brought that up, Your Honor. I disagree. Actually, the standard of review for harassment prevention orders is that the appellate court, your panel, must scrutinize without deference the trial court or the juvenile court judge's assessment of the evidence. So that is to look at the legal criteria as it was assessed and applied to the credible facts that were presented to the juvenile court judge at the time. And to remind the panel, there were several people who testified and several exhibits.
Doesn't the judge get to make the credibility determinations?
Oh, generally, the trial court judge gets to make that credibility determination. But here, where the standard of review is without deference, I believe that you essentially have to review the evidence yourself and independently analyze the application of the law to the credible facts presented to the trial court judge. And that, to an extent, is important in this case. As you said, I laid out the facts that we believe support our position, but those are clear facts and on some points uncontested facts that support our argument that there were not 3 willful or malicious acts as necessary to be proven.
Is the thrust of your argument that there weren't 3 acts or that they weren't willful and malicious?
Both, Your Honor. So I can go through the 3 acts if you like. So for the first act, just to summarize, the 3 alleged acts were that on September 17th, out at recess, SJ asked who was allergic to nuts, went through a line of students. BW identified himself after 2 other students identified themselves as being allergic. By that point, the teacher at the time, Miss Coleman, had told SJ to put his nuts down, which he did. That is actually uncontested in the testimonial record. That's what SJ testified to. That's what BW testified to. And if you look at Exhibit 4, which was the first incident report that was generated by the school staff, that is also what Miss Coleman told Miss Williams at the time, that she directed SJ to put down the nuts, and he did. None of that testimony or the most immediate evidence from that time says that, or proves that, or even supports that SJ intentionally took out a container of nuts, opened them up, and blew nut dust in BW's face. That's
what about?
Go ahead.
Go ahead. What about BW's affidavit from September 25th, 2019? It's in the appendix at page 5. There's no mention in the affidavit of teachers intervening, but it says he pulled out nuts and blew the dust of the nuts in my face on the playground. When we came inside, he asked me again, "Are you allergic to nuts?" I said, "Yes, I am." Then he pulled out the nuts and blew them in my face again. Then it says he later threw the nuts at him.
Yes, BW, Your Honor, BW testified at the hearing, and he contradicted himself. That written statement, by the way, was dated 8 days after September 17th, though it's characterized as being in his own words. I think you could look at his IEP and his diagnoses and the communication disorder and question who did write that, but also what happened in the meantime. When BW presented himself to the court and his mother asked him if he knows the difference between a truth and a lie, and he said yes, and she asked him what happened out at recess, he said that Miss Coleman, he referenced Miss Coleman, and then he said that SJ put it down or put them down, something to that effect. So what you have directly to the court is that. On that issue, you also have SJ's mother's testimony directly to the court that when she followed up later that afternoon, that she spoke with her son, SJ, in the presence of Miss Coleman, the teacher, and that he confirmed, SJ confirmed for his mom that he put the container down when directed, and Miss Coleman nodded in the affirmative. And she did not intervene at that point and ever claim at that point that SJ did otherwise, meaning she did not say right then and there that he opened up the container and proactively blew nut dust in BW's face. And also, she did not say that to the co-lead teacher, Miss Williams, as you can see in Exhibit 4. However, her story changed for whatever reason, we don't know, as of the next day and beyond. There are a couple other exhibits which happen a week later. That's also consistent with BW's statement or the statement attributed to him 8 days later. In terms of the second allegation of inside the school and outside the bathroom, SJ, who had been consistent throughout his statements from his in-person statements that day to his written statement to the court, as well as his testimony, stated that when they were inside, they were lined up and people went in small groups into the bathroom, and that he did not approach BW, he did not open up the container of nuts and blow anything in his face. You mentioned BW's written statement from 8 days later, but when you contrast that to BW's testimony before the court was actually that SJ did not directly approach him, and BW did not actually experience what he previously claimed. He did not experience SJ opening up a container of nuts and blowing the nut dust in his face. What he claimed instead was that some other unnamed student claimed that SJ was blowing nut dust around and that that BW accidentally smelled it. I do think this strains logic as to what he was claiming, and then also significantly contradicts what he or someone on his behalf was claiming at the time or 8 days later after September 17th. And then the third allegation is that SJ in the classroom after these first two alleged events then threw nuts at him. It is absolutely clear from the record that this did not happen and it could not have happened. And all you need to do is look at BW's statements. So I'm glad, Your Honor, that you brought those up. In his written statement from 8 days later, he does not even mention this. If this had happened, it certainly would have been in that statement. BW testified at the hearing.
Well, no, he says, it doesn't
testify.
I'm sorry, it says, it does say it, doesn't it? It says, but then when I came into the classroom, he threw tree nuts at me.
I do not recall that, Your Honor. What I recall is that the mother of another student claimed that student who had a bullying history against my client claimed that my client, SJ, threw nuts at BW. What BW does say in that statement is that on his way to the classroom, the teacher, Miss Coleman, brought him to the nurse. He never went back to the classroom. And that is also consistent with what my client, SJ, testified to and put in his statements, that while after the bathroom aspect of the allegation, that he was brought directly to the office to meet with the co-lead teacher, Miss Williams. SJ, my client, never went immediately to the classroom at that point. He was brought separately to the office, and BW never went back to the classroom at all for the rest of that day. He was brought either by his statement directly to the nurse or by Miss Coleman's statement from the classroom to the nurse. Miss Coleman, who was with him throughout this time period, never mentions that SJ threw nuts at BW, because it didn't happen and it couldn't have happened from almost all the evidence that was before the trial court judge. My recollection is that the only reference in the record to this is through many levels of totem pole hearsay attributed ultimately to a student who has a bullying history against my client and is contradicted by everything else in the record. So there is not credible evidence. There was not credible evidence before the court, and I do not believe.
Let me ask you, my recollection of the transcript, Ms. Coleman doesn't testify, right?
Ms. Coleman, the teacher, does not testify. Right. Just Ms. Williams, the co-lead teacher, who is essentially a co-principal, the administrator.
Okay.
So do you take a position that if someone fills out an affidavit in order to, get a restraining order or harassment prevention order going, if they then testify in person, it's the live testimony that is the evidence in the case, and the affidavit is to be disregarded? I'm trying to figure out what your position is with the status of the affidavit in that circumstance.
Yes, the affidavit is not evidence. It's just essentially like the equivalent of a charging document for a case. So it is what gets you over the initial hurdle, if you will, of getting into court. You file the affidavit in support of your petition for the issuance of the harassment prevention order. So I do take the position that the affidavit itself is not evidence, but it does essentially lay out what the original 3 allegations were, which carried over into the testimony and the exhibits before the court. So yes, I do believe that the evidence before the court is the testimony of the witnesses as well as the exhibits. Of course, you can't look at that in a vacuum. The trial court judge, as well as I believe under the standard of review that applies here, this panel must scrutinize without deference. So it's essentially a review of the evidence. A determination needs to be made whether or not there's enough credible evidence to support all of the elements that are required to be proven by a preponderance of the evidence for the issuance of a civil harassment prevention order. I will also note that in the evidence that it's clear that SJ, the minor defendant, was interviewed that day by Miss Williams, the co-lead teacher, and it was clear to her and clear in the evidence that when she was speaking with him about a nut allergy, she understood that he did not completely understand what it meant to have a nut allergy. It's also clear in the record that the family as a whole, the SJ family, SJ and his parents, were never notified in advance about the allergy that any student may have had. SJ's mom was clear that she would have never sent in the nuts in the nut butter sandwich for her son SJ to eat. So SJ did not know leading up to the questioning in the line at recess about the allergy. And then when he did hear from his teacher, Miss Coleman, about the allergy, he put the nuts down or away. He has been clear about that all throughout. And
so your red light is up now.
Thank you, Your Honor, for the reminder.
Yeah, no, thank you. Your brief is very good, and we will scrutinize the record. Are there any more questions from the panel?
We are live and on the record.
Okay, thank you. Good morning again. And so this is the fourth argument for our session on October 16th, 2020. As you know, this argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. Nonetheless, we follow the same rules and customs as in the physical courtroom, except you may remain seated while you're speaking. Once we get going, where the session clerk was appearing, a countdown clock will appear. It won't turn yellow and red as in the courtroom, but it shows 15 minutes and will turn red at the end. Each side gets 15 minutes. There's no rebuttal. Only one advocate will speak at a time, and the other one will be muted while it's not their turn. However, we can still see you, and so please stay on the screen, but keep your reactions and gesticulations to a minimum. As you know, the proceeding is being recorded. It will be archived and available to the public now and afterwards. As you know, this is an impounded case, so we'll be using a pseudonym for people's names. And as always, we've read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, we won't hold it against you if you don't. And with that, let me call the case, which is Doe number 199212 versus Sex Offender Registry Board, our docket number 19P820. And Mr. Burkholder, you're representing Mr. Doe. The floor is yours.
I am. Good morning, Your Honor. Fred Burkholder on behalf of Doe 199212. I find this to be a very interesting case. Before I proceed much further, I do want to point out to the court that there was one decision which came to my attention during preparations, which I want to bring to the court's attention. I did not get a chance to do a 16L letter. I had two arguments yesterday and it got past me. That case is 234076. And the citation for it is 484 Mass 666. It was decided earlier this year. It's of importance because the matter was remanded based upon consideration of offense-free time prior to incarceration and prior to the incident, which is in fact what is relevant here and one of the things that Dr. Brown relied upon. Obviously, you got two major arguments. The third one is dissemination, which is present in every case. So I'd like to first talk about the 1998 offense. I'm well aware of the fact it's substantially reliable evidence. It can be considered. I'm well aware of the fact that a police report in and of itself can form the basis of that. However, nonetheless, it's supposed to be a reasonable determination of whether or not there's substantial reliability. And I think there's certain factors the court needs to at least consider before my argument is summarily rejected. Those are the following. First and foremost, the individual in question admitted that he had engaged in sexual contact with this young lady. But he also said, listen, I was told that she was 18. Me and my manager both were shown an ID that suggested that. Now, statutory rape is a crime in Massachusetts. Knowledge of one's age is not certainly a defense to that. However, when we're talking about reliability, we're talking about substantial reliability, I think that it at least is entitled to some consideration.
I have a question about that.
Yes.
Why would a 13-year-old have an ID that shows she was 18? I can understand why a teenager might have an ID, fake ID to show they're 21 to be drinking age. Whether or not that would work for a 13-year-old is another issue. But couldn't the hearing examiner disbelieve the defendant's claim that, or sorry, the plaintiff's claim that the girl showed him an ID?
No, and I'll tell you why. Because 18-year-old IDs do exist, and they exist for a couple reasons. I actually have a daughter that's now 25 that went to college here in Boston, and she started at 17. And the importance of an ID for age 18 was critical for a couple things. First of all, to buy tobacco products, she had to be able to establish her age. Secondly, some of the clubs that the kids try to get into are non-alcoholic, but you still have to be 18 in order to enter. So it's not unreasonable at all for someone to have such an ID. As a matter of fact, as I understand it, Suffolk University even had a system where people could obtain through their assistants an ID to establish their age. I understand the logic that you're going to want to have one that says you're 21 because that will allow you to consume alcohol, but there are other reasons why someone would have one. You may not believe it, but nonetheless, there is a videotape that I understood. I did not see it, but also there was a manager that came forward and the like.
So, so the victim 3 here alleges not that she was raped, by the way, that she was indecently assaulted, and your client admits that he had intercourse with her.
Absolutely.
So isn't it kind of reasonable to infer that something happened?
Well, I don't disagree that something happened. What I'm asking the court to consider is whether or not it should be deemed substantially reliable for consideration of factor 2. This case is all about factor 2, in my opinion. It's all about repetitive and compulsive. It's all about the existence or non-existence of showing a deviancy.
But it's fairly uncontested that in 1998 he's having sex with a 13-year-old.
I don't disagree, Judge, but what I'm trying to say is he didn't know that. And again, it's not a defense in a criminal case to know that, but we're talking about compulsiveness. We're talking about psychological impulsivity. We're talking about the inability to control one's urges. And that's a different standard than beyond a reasonable doubt in a criminal case. That's what I'm saying. And the court's already pointed out a couple of things that are of interest. Number one, there was only a police report. Secondly, of course, she didn't appear. Thirdly, the only corroboration was from her mother, and she told her mother a different story than what she told the police. So,
what about the blood?
Well, I don't disagree that an offense or that an interaction occurred. I don't disagree with it whatsoever. I do not. That said, there are inconsistencies that at least I'm asking this court to consider with regards to application of factor 2. Now, I'll move on from that because it seems like my argument may be falling on deaf ears. That said,
no,
and I'm limited in time, I want to talk about Dr. Brown's opinion. You know, we fight and fight and fight, and if I could see my esteemed colleague's face more clearly, because I would see a smile on his face. In that we fight very hard to get a expert to finally get funds to hire an expert. We finally are successful in a case like this to get such funds. Then we have that expert who is very well respected, who serves as a QE in SDP cases, and certainly should be given credibility. And under the most recent case that I just cited, they're deemed to be reliable anyways once funds are afforded to them. So he comes forward and he offers an opinion. And then that opinion, of course, does not have to be accepted by the hearing examiner, but nonetheless, you've got to have an objectively adequate, reasonable reason to do so. And my argument here is that there was not that objective, adequate reason. The first and foremost reason I want to talk about is consideration of the factors. I cited a case previously in my brief. I can repeat it if the court permits or court requires, but it says that consideration of all factors is not necessary, and the failure to do so is not an objective, adequate reason to discard it. That's case 23656, and it's cited in my brief. It's set forth there. So what do we have here? We have Dr. Brown, who serves previously as a QE. He's going to look at the underlying issues and try to determine what the basis was. I'm sure this court's well aware of what SDP cases are about. I'm somewhat new to them, but I have at least wet my feet in the water long enough to know that the emphasis is upon the existence of a mental abnormality or personality disorder, and which causes a loss of volitional control. Why is that relevant to you?
Can I ask you to step back for just a second?
Yes.
So it seems like Dr. Brown is offering an opinion basically on the same thing that the hearing examiner is supposed to come to a conclusion on, right? I mean, isn't that right? I mean, it's not like he didn't have like he didn't focus on a specific aspect of Doe's behavior, but he just said, here are the factors. This is how I would look at the factors. I mean, and is that,
yes,
is that fair?
Well, no, I don't think it's fair for a couple reasons. First of all, with regards to factor number 7, which is the degree of relationship, although the Regulation 7 requires that there be a 2-year living arrangement before it can be considered an incestual relationship, these people were together for a period of time. According to the police report, the offenses started in October of 2002, I believe it was, immediately after he moved in. Nonetheless, the doctor opines that it was still in the nature of an incestual relationship, and in that, that's how long he lived there. Why is that relevant? Because that limits the target pool considerably, and the degree of risk that be associated with an incestual offense versus a extrafamiliar or a stranger is much, much lower. That's the first consideration. The second one, yes, they're both trying to determine compulsiveness, but the doctor comes out and actually says there is an explanation for this gentleman's behavior. That explanation was his prior diagnosis, which is set forth in great detail, and I don't need to repeat it, but I'm certainly prepared to do so if you wish me to, and that he was not receiving any treatment for that at the time. And then he goes to the institution. Surely he doesn't do fairly or extremely well in SOTP, but that said, he at least gets an exposure to it. And now when he gets out, he gets hooked up with the McInnes group, and he's going to be seen. And hopefully they will, of course, provide him with the meds that he needs.
Counsel?
The doctor then concludes that, yes, Your Honor.
I'm interested in hearing more about the issue you raised with the 16L letter case about the amount of time, offense-free time.
Okay.
And I'm wondering what you have to say about the D reports from 2010 and 2016 that seem to be sexually related.
I don't have an explanation for those, Your Honor. I wish I did, but I do not. I'm aware of them. They're right here in my hand. I pulled them and I said, we're going to talk about those, but yet I wasn't present, and the underlying police reports were not made part of the record. So I can't speak to whether or not they were with another inmate, or whether or not they were involved a situation that was off-site. I believe he was out at a work crew. So whether that was somebody that he got involved with that was a member of the public rather than someone that was I don't know. And because we don't have the police reports, I can't answer it. They're of concern to me without any question, and I do see them, but in and of itself, the weight that was afforded to those reports, frankly, I'm not going to disagree with. They're concerning, but you spend that number of years in an institution, you're probably going to pick up some complaints. The basic police reports, we call them, or charges that exist in the institution, for the most part, there's something that occurs there on a fairly frequent basis, whether it be standing in line, disagreeing with the officers are involved, having some conflicts with the people that are in there, and even some degree of violence. Those are of concern. I wish we knew more about them. I don't. That was your first question. Your second question was the offense-free time. That's of significance because, as I indicated in the case that I just mentioned, there was a challenge made with regards to testimony that was offered by, I think it was Dr. Bard, who came forward and said, I don't see any evidence of repetitiveness and compulsiveness, same thing that was offered here. And one of the reasons that I do so is because of the fact that there was a 4-year period of offense-free time. And here our SORB counsel objects and says 129 does not encompass that because they only talk about offense-free. That only encompasses offense-free time that occurs after an individual has been incarcerated. And the court said, no, number one, it's relevant. And number two, we want to hear about it because it's not encompassed, and they sent it back for consideration. So that's one of the bases. When I look at these cases, and I look with great emphasis upon the high risk factors, because those to me are the most important. And if they exist, then I have issues. Yesterday, I spent all day arguing about whether or not there was a need for compulsiveness in these cases. That argument was not made previously, or you'd be hearing me talk about it again. But I couldn't make that argument because my esteemed colleague didn't raise it, and I was quite surprised, although she tried. And if you look closely at the record, she tried to admit the transcript of Dr. Hansen, and that was summarily stopped, period, end of discussion, don't talk to me about it anymore.
Is that this case or yesterday's case?
What's that, please?
Is that this case or yesterday's case?
No, this is in this case.
Okay.
She tried to introduce the transcript, and she was stopped and said, no, it's not even relevant, considering it was listed as an identification exhibit. It's not in the file or otherwise, and we all know what that says. It says the repetitive conduct in and of itself is not an indication of repetitive and compulsiveness and the like. So, and there's obviously been a case since then that said that was an error, whether it be 22188 or the subsequent cases that have come out. that wasn't raised at the Superior Court level either, so I can't talk about it other than to say my focus again comes back to compulsiveness and whether or not that was present. How do you get to compulsiveness, or how do you get to application of factor 2 here? You either get it by relying upon an offense that, frankly, my guy admits, but was duped, if there's not a better word, as to the age, if you believe him, or that there was no evidence actually of compulsiveness based upon a doctor of reputation that should not be questioned that says it wasn't there. There was another reason for his behavior. He had a substrate of anxiety and he wasn't properly treated. And once he became treated, he started to recognize, the importance. I can go into some of the other bases for the rejection. I think that they're some of which I agree with. I mean, you have to consider a PPG. That's what the case law says. The doctor didn't do that. In and of itself, do I have that much faith in the reliability, scientific reliability of a PPG? No, but the court's found that it has. Whether or not the static 99 was in fact properly interpreted, the doctor said give him level 3 or give him 3, and yet the comprehensive evaluation said a 4. The difference is whether or not the 2007 offense was in fact resulted in a quaff. I have as Corey. I looked at it this morning because I didn't remember that either. It was not a quaff. It was a dismissal. So nonetheless, the hearing examiner found it considered. So we're talking about, I think that those, and then he parses whether or not he got the age right because it was the police report charged him as a under 14-year-old, even though.
Mr. Burkhold, I'm gonna stop you. We got the time has expired. Let me see if the other justices have any questions.
Sure.
Okay, I think we get your argument, and very well presented. Thank you. And so we'll now turn it over to Mr. Shinai.
Thank you, Your Honor. David Shinai for the board. I'd like to start with factor 2. Compulsiveness really isn't an issue here because the Hansen testimony and all the research says, and Doe 22188 says, if someone commits a or act of sexual misconduct and is confronted by authorities, and in this case, this individual was confronted and is charged criminally, then if they commit a second subsequent act of sexual misconduct, well, that represents repetitive and compulsive behavior. And in this case, that's exactly what happened. It doesn't matter what he believed that the young lady's age was at the time he committed it. The fact was he was confronted and at some point knew that she was only 13. He went to court on that. So he was confronted, he was charged, and then he moves into a home with small children and starts sexually abusing them within a month of moving into the home. So I don't think factor 2 really is an issue here because of Doe 22188 and even Hansen's testimony on that issue. The second part of this issue is that factor 7 specifically says that it's intrafamilial only if, in circumstances where the offender moves into the home, as if he's been living in the home in excess of 2 years. The reason for that is because someone who moves into a home with small children and begins sexually abusing those children within that 2-year period is actually acting as a predator as opposed to a stepfather or a parent guardian situation. And that's what happened in this case. And that kind of leads into the expert's situation. A hearing examiner does not have to accept the opinion of an expert where that opinion is undermined by facts in the evidence. And in this case, that happened. He didn't believe that moving into the home and sexually abusing prepubescent children, he didn't believe that to be controlling in any way. His belief was it was intrafamilial, so he really has a reduced risk, when in fact, it's more of a predatory act. And it showed because of factor 3 will tell you if it's a prepubescent child, he's showing deviancy. And the fact that he went into that home and did what he did shows that deviancy, and that deviancy also was shown in the PPG in 2016, in which he specifically was found to have sexual reactions to coercive and non-coercive sexual activity with minor children. So, and then the other part
Mr.
of
Chair,
it
can I
is
ask
that-
you just, can I just,
Sure.
what is the current status for PPG evidence?
Right now, it's admissible in these hearings to determine whether or not an individual shows signs of sexual deviancy. And in this case, he did. And it's interesting, as Dr. Brown said, that because he does not condone sexual behavior with children, that means he's no longer a risk to children. I mean, that's a self-reporting. It's not even measured in any way. And again, in direct opposition to the PPG test. And again, this isn't a PPG test that was taken in 2007. It was taken in 2016, fairly close to his release date and fairly close to the actual hearing. And then I just point out one more thing is that DOE 234076 did not say that the board has to consider offense-free time before incarceration. What it said was, if an expert comes forward and says, or makes that opinion and discusses it, the hearing examiner at least has to consider it. Doesn't have to accept it. The hearing examiner doesn't have to accept that opinion, but it has to be considered. In that case, in 234076, the hearing examiner did not consider it, wouldn't consider it, and that's what the court said. It's got to go back at least to have the hearing examiner consider that evidence. And finally, you know, I know no specific findings were made as to internet dissemination, but it's important to note in this case that, again, this individual moved into a home where children were there showing a deviancy. He actually sexually abused those children within a very short period of time. And then on top of that, the PPG shows he still has deviancy towards children, and he's been in prison for a good portion of time. And then even while in prison, continued to misbehave in a sexual manner. So based on this, it's the board's position is not only is the hearing examiner's decision based on substantial evidence and a well thought out decision, but that the board, not only should this court uphold it, but the court should also allow the internet dissemination on this matter. And if there's no other questions, I'll rest on my brief.
Seeing none, we'll accept that.
Thank
you both. Very, very well.
We are live and on the record.
Okay, thank you. I think it's still morning. This is the fifth argument in our session today for October 16th, 2020. As you know, the argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. We will follow the same rules and customs as in the physical courtroom, except you can remain seated when you're speaking. Once we get going, the session clerk will display a countdown clock on her screen. Each side has 15 minutes to argue, and there's no rebuttal. Only one advocate may speak at a time, and the clerk will mute the other advocate until it is your turn to speak. But remember, we can still see you, so please keep your reactions and gesticulations to a minimum. The proceeding is being recorded and being archived, so it's available to the public now, and it will continue to be available to the public after this. This case is an impounded case or partially impounded case, so we will be using pseudonyms. And we will be referring to people by their descriptions and relationships rather than by name. As always, we have read your briefs and we're familiar with the case. And although you're free to use all 15 minutes, we won't hold it against you if you conclude early. With that, I'm going to call the next case, which is 2020 P20 NM versus PR. And Mr. PR, you are the appellant, so you have the floor.
Good morning. Thank you. So if you refer to the affidavit that was placed in front of the Somerville District Court by NM, you can see that there is no actual dates, incidences, description of any verbal harassment. Even up to this point, there has still been no documents of any verbal harassments or threats to this individual. Just going by that alone, this affidavit should have never passed the judge in the Somerville District Court. There is nothing to reiterate this affidavit and is in violation of my due process, in violation of my Sixth Amendment. I stepped into a hearing, even having this affidavit in front of me, unknowing what the cause of action was until the hearing began. So under Rule 56, we asked for summary judgment. I think we had met the criteria for summary judgment, as this affidavit has nothing. It's an absolutely baseless and fraudulent affidavit. It's based upon perjury. It's under, with the aid of a Somerville District Court judge who most likely has violated some of his canons, and furthermore went on to a hearing where it was a one-sided hearing with a justice that didn't really care to uphold my rights or my amendments. So that's first and foremost. If the Rule 56 needs to be amended for any specific clause, we'll be glad to do so. Moving on to the matter at hand, I really don't think I really need to go into details because that pretty much should sum up and have this case immediately brought back down, reversed, and continue to be impounded and removed from my permanent record, as this is quite damaging to my record. That is the request that has been made.
Can I ask you a question?
Sure, yes, ma'am.
Okay, so I understand what you said about the initial hearing and the affidavit, the general affidavit. So you did proceed to a hearing and the judge did take evidence, I understand, from yourself, your brother, from the other party. At that point, there were also documents that were submitted. Is that correct?
Yes, NM presented some email documents.
Okay.
And I had, prior to, submitted several motions to the court dictating that basically if the court was to go forward, that they were committing a crime against me, which I am absolutely convinced and entirely positive that a crime has been committed against me by the Somerville District Court in collusion with the attorney in question.
Mr. PR, I have some specific questions about the record. It was a little unclear to me as to what was actually before the judge, because there was a lot of conversation generally about documents. I've got the documents, and then there are things that are presented both in your appendix and in the other party's addendum to the brief. It's unclear to me that all of this was in front of the judge. Is there anything, from having looked at the record in this case, did you see anything that wasn't actually in front of the judge?
I had presented motions to the court prior to the hearing. There was nothing in front of the judge from the other party until the hearing began. That is an absolute violation of my Sixth Amendment. I am there to defend myself against something that I have no idea what exactly it is.
Can I ask you, again, sir, just if I can ask you, as I read the transcript,
Yeah.
There was a lot of focus on a couple of emails, it seemed, within minutes of each other, something to the effect of time expired, your time is up. Okay.
Correct.
I noticed that in the email indicated that there were attachments.
Correct.
Can you tell me what those attachments were?
Yes. So I was seeking my mother's will. My mother had passed away in May of 2017. And the attorney, the other party, had my mother's will. She had sent the wrong will to my prior counsel. I had requested from him to seek the will. He said that the attorney had not answered him. I had another counsel that was involved in a Superior Court matter. They said they'd seek the wills, but they'd not been answered. So I was left on my own to seek this will as the personal representative of my mother and the personal representative of the estate. I sent a 20-day demand notice with a request for my mother's will, with a 20-day legal notice for a request for my mother's will, along with other documents, as now I was the personal representative of my father's estate.
Were those attachments before the trial court?
Absolutely. And then I had sent a 30-day demand letter under a 93A requesting my mother's will. Again, the attorney, other party, had stated in the transcript that she had not answered me. So my third attempt to get the will was those emails that transpired on November 12th, 2017, that stated your time has expired with the 20-day notice and a 30-day time demand letter, which has been contrived and bludgeoned by the lower court's judge to be a threat against the other party. Which is,
PR, did you state that those emails were from 2017
yes.
and this hearing took place in 2019?
No, I'm sorry. Those emails were in 2019. I apologize.
Okay.
Yes, they were 2019 emails.
I just a point of clarification. I understand the 30-day demand letter was from 93. What was the 20-day?
As a 20-day legal notice.
Where did the 20 days come from? Does that come from a statute or?
I found that there's a 20-day legal notice that you can send. So I sent a 20-day legal notice. I'm, as you can tell, I'm pro se. I didn't have counsel. I wasn't advised. I sent a 20-day legal notice requesting my mother's will along with other documentation. It was ignored. I had then later in the month, and this was late August, I sent the 30-day demand letter under a 93A, which, by the way, the lower court justice says that that's not the way to demand anything via a 93A. Like, she seemed to be really confused.
I take it though, your argument is that when you say your time is up, your time has run out, that is not a death threat. That is talking about a 20-day and a 30-day.
Correct. The absolute time noted attachments, which was clearly presented to the lower court and ignored and then contrived to be a threat in participation to aid the other party. It was just a disgrace what transpired in the lower court. I'm sorry.
And I mean, I guess the question is though, could the judge, although could the judge reasonably infer from the course of conduct and the relationship between the parties that there was something behind that it was more than just a referring to a time lapse?
Absolutely not. There was no communications with this party since 2017. Prior to my parents' passing, there was a 2-year window with more than a 2-year window with no communication at all. And then the only way the emails were only sent to verify that I was protecting myself because I was going to have to proceed with criminal charges in concealing documents that I needed to file in probate court, which is my mother's will. So I had, to cover myself, I had sent 2 emails to verify that they were both communicated and not spammed, and that they were received. This way I had an electronic record to protect myself as I was going to go forward with criminal charges because the party was concealing documents in official proceeding, which I had to get through. I eventually got in December of 2019. So that's how that all transpired. So I have no idea how the lower court decided what they did decide and why they ignored that the time dated materials were not material fact to the matter, that they were threats. There were no threats of any nature ever to the other party.
Excuse me, could Judge Campbell consider the March 3rd, 2017 email? I hope you suffer in death like my mother and burn in hell, you disguising excuse for a human, F you. Could the judge consider that from 2017 in determining the meaning of your time is up in 2019?
No, I don't see how they would be related. That communication was made after it was apparent to me and my other sibling that the collusion and conspiracy with the law firm that the other party represents worked with my oldest sibling to convert over $316,000 of my parents' assets into his personal funds. This is a Superior Court case. The finding is in the Superior Court case of a $316,000 finding. That was my state statements made, which are protected under my freedom of speech, that were made after it was clear that the other party was being very deceptive and misleading and misrepresenting their purpose. If you look under documents, it says that they were going to document my parents' assets. And as the trustee of my parents' trust, I was responsible for those assets, and those assets were never documented for me. And those assets that my older sibling got 25 death certificates for 25 assets. I know of one of those assets. The other party colluded with my older sibling to conceal and convert those assets. And there is testimony in the Superior Court case that he had taken those assets based upon his counsel's advice.
Mr. PR, just a couple questions for you. At the time of this restraining order hearing, is it correct that there were two proceedings going on at that time, two proceedings pending, one in Superior Court and one in probate court?
Correct.
Okay. Was there a resolution in the Superior Court case?
Correct. There was a jury finding of over $316,000 of conversion had taken place, basically pure larceny.
And that case was ongoing while this hearing took place?
Correct. So the assets, the documentations and the facts speak for themselves. I haven't, everything that's in my appellate brief is documented. It's factual information. It's not a story. It's what transpired with my parents, who my father ended up being trapped in a hospice house because the partner attorney of the person, the plaintiff, had taken told me that he was the attorney. In fact, that he had, my older brother had transferred the POA to him. There is no substitution clause in that POA. He committed a crime. They worked to commit a crimes. If you look under one of the documents I have, they're saying there's no money available. Yet the day after my father passed away, the ILOTA account of that law firm transferred $35,000 to my older sibling. It is documented. It is sent into this court. It is sent in the Somerville district. It is sent to in the Superior Court, documented. So they're stating that there's no funds, yet they have $35,000 of funds that they transferred to my older sibling. Those two individuals conspired to pillage my parents' estate to take advantage of two elderly people who were not competent. They will testify.
Mr. PR, I'm going to
Sure.
stop you. You understand that, I understand there's a long history here, but really the only thing that's before us is whether there are three threats or not.
Correct.
Yeah, okay.
Yep, but you need to understand the whole story as well, and the facts that developed why there's communications between my party and their party. There would be no communications between my party and their party had the will been processed to me when my mother died correctly, and had there not been collusion, there'd be no emails back and forth to them with the statements that I made. The statements that I made have been substantiated through trial. So my beliefs and my written statements were documentary of the time, of the facts of what was transpiring, and it has been proven in a court of law. I will move on to other issues as we go along here.
Actually, you have about 15 seconds, so you might want to sum up at this point.
Yeah, well, there has never been any threats at all. There is nothing that compounds any threats. My documents in the appeal brief are very clear. The case law is very clear. And again, the affidavit itself should have never made it even to a hearing. There should never been a hearing.
All right. Thank you very much. We have all your information. We have the briefs and we have your argument. So very well done. Thank you. It's now 15 minutes for NM, and then we'll adjourn after that. So
thank you, Your Honors.
Thank you. Just a second. There we go.
Excuse me. May it please the court. My name is NM and I am the appellee. Can you hear me?
Yes.
Okay, thank you. The question before you, the only question before you, is whether the lower court correctly ordered a civil harassment protection order against the appellant. I believe that the court should find in favor of the appellee and affirm the order for these reasons. Mass General Law 250-80 is the correct law used to decide this matter. The lower court's ruling follows the standards of review for 250-80. The decision is correct and on the side of the appellee. The lower court followed Mass Rules of Evidence Guidelines 1106 and did not deny appellants' rights to due process or free speech. And lastly, the appellant's appeal is patently meritless and transparently frivolous. I do want to clear up just two matters before I continue. The matter that he's talking about in Superior Court was not heard until several months after this matter. This was done in November and the trial started in January. So anything that he wrote prior to January, or he's writing now, has nothing to do with the harassment because the decision wasn't made. I was not a defendant in that matter. So, I mean, there's been a lot of name calling, but it was not me. My firm represented the appellant's parents, elderly but competent, who engaged my firm to help them achieve peace at the end of their lives. Appellant was one of their three sons, and it was he who created the havoc because his parents, although elderly and competent, were a little stubborn, and they would not relinquish control of their lives to them. His harassment has been ongoing since 2016. As plaintiff in the lower court, I had the burden of proof. I had to show that the preponderance of evidence in at least three events using as showing harassment, I used that as evidence as well as my testimony. And it proved that the defendant had harassed me and caused me harm. I used only the emails that were sent to me from the defendant. That's it. And they were given at the time when I met the emergency court judge, when I applied with the affidavit, and they were in the folder when they went to the lower court to have the hearing. I don't know what was sent to the defendant. I was not in charge of filing the charging order with him. So that would have been a court responsibility, or he could have called and asked for it. That's what I used, my oral testimony and his emails.
So there's, I mean, so, you know, there's a voluminous record and we've looked through it all. And the emails are definitely heated.
Yes.
But there's really only one that rises to the level that seems to me to rise to the level of a blatant threat. It's one that Justice Grant read earlier. But besides that one, what are the other two that the judge relied on?
The judge relied on that November 12th. I mean, I handed them all to her. That she was very big on the 33217, where he's threatening me about suffering and death and swearing at me. And I mean, that's
the one. That's the one that we were.
Right.
Two.
That's right. The other one was the two that came in the 5 minutes. And by the way, I did not have an attachment. That attachment was not provided to the court.
When you received the email,
I didn't open anything except forwards. There were, if I may explain, I got up in the morning, went to my office, turned on my computer, went to my email. I saw one email, told me my time was up. 5 minutes later, another email, your time is expired. I had just, and I put this in my testimony, I had just lost my husband after a 3-month terrible ordeal for him. It was like, what is this? I didn't look above at the heading. I didn't see an attachment.
I assume that you didn't share with PR any what was going on between you and your husband, though.
Absolutely.
So he wouldn't have been
No.
aware of it.
No, I didn't say he was aware of it. I'm just saying this is how I perceived it when I came in. To me, it was a very big threat because things had been escalating since the first one. I mean, he was not his parents' personal representative or their trustee while they were alive.
Ms. NM, you said things had been escalating.
Well, from the beginning of the
Is
beginning
it
of my,
true that there was a 2-year gap between all of those emails in 2017 to this period, 2019, where I assume, I believe you testified that you got the demand letters?
I did
earlier?
get I got a 93A, yes.
Right. So you got those letters, and then that was followed up about a month later by these emails saying your time is up.
Well, now I'm hearing there was a demand, a 20-day demand. I don't recall receiving that, but so it wasn't 2 years. No, it was less than 2 years. But his parents had died, so there was no reason for him. And to make it very clear on this record and every other record I've been on, I did not have his mother's will. I had a copy of it, and I did not have it. I don't know where it is. He's had lawyers before. His mother had a lawyer that provided it. He had all of the records from the house. It's when he also harassed me, as I told you, libeled me in 2017 in the Peabody District Court, where he called me a liar to the judge. I have the transcript is in the material that I submitted to you. The judge again had to explain to him about attorney-client privilege. His parents were, he doesn't understand that. And yet when he comes to this court and the judge instructs him on it, I never heard of it before. But so there's two issues there, but the bigger one is that he stood in front of a judge after he lost his case and said to the judge, "You're a liar. She's a liar." To me, that was very threatening. I could have been disbarred if the judge had believed him.
Well, the threat has to be for physical, to
No, well,
injury.
I think I'd like to disagree with that, Your Honor. As far as the case with Aegis versus Howard Johnson, they did enlarge the case. That is in my brief. They did enlarge the matter in the 258E to Aegis versus Howard Johnson. They expanded liability for emotional distress in a 258E matter to cases without physical harm. I can give you the site if you would like that.
It's in your brief. It's in your brief.
Yes. But if you need the full site,
no, we have it.
Okay, thank you. His due process, I do not believe, and I'm ready to argue it, but I do not believe that his due process was denied, and I do not believe his free speech was denied. Free speech has limits. The limits are fighting words and true threats. And I think when you hear what he says about me, when he calls me, what you see in his briefs, what he did in the emails, in more than one email. In fact, I will just give me 1 second to find it. In March 2020, I'm sorry, February, I'm complicit. I've held them hostage. I have entirely complicit, and I'm legally responsible for outcomes.
Isn't that from 2017?
Yes. I'm sorry, I copied 2020. Yes, it's 2017. I have one from March of 17. That's the suffer and death one. Then the 2, and then he says the 20. You have to understand, Your Honors, this, while his emails may have stopped for a bit, the matter did not stop. You've heard his testimony today. It just goes on and on and on. And the judge was very clear clear as to what she felt about his true threats, about what she felt about his malicious language, his due process. I believe that this lower court conducted herself on the SJ based on the Mass Rules of Evidence guidelines in every single matter. He doesn't allude. He says today that the judge was on my side, and the first judge, he's actually in his brief said that he wants to take criminal charges out against the judges in the lower court. There's a lot of threats throughout everything. His freedom of speech, he lost that right to freedom of speech. Chaplinsky, who he quotes, says anything that's lewd, profane, and libelous and insulting is a true threat. They actually named those in the O'Brien case, those words, fighting words. They define the fighting words as lewd, profane, libelous, and insulting. And his other case of O'Brien, in the O'Brien matter, excuse me, he talks, okay, in O'Brien, the court declined, the SJC declined to find Chapter 250 unconstitutionally overbroad. It has to be a true threat or fighting words. Article 12 of the Declaration of Rights limits exceptions to free speech to these. Welsh and Robichaud said that the First Amendment does not protect conduct that threatens another. In Welsh, harassing speech or conduct does not qualify as protected speech. So I do not believe that either he brought it up, or he in the lower court, or that he had protected speech in anything that he's written to me. He's used language that is just one insult, one threat after another. And those two at the end, having been preparing for this trial, because the trial was preparing, just frightened me. I can't even explain to you how I started to look around my car to see if my tires were being slashed. And I'm not a frightened person. I don't frighten that easily. The allegations that come out of the appellant's mouth at all times and every time are very frightening. So we've been in probate court prior to this, and he says the same things in the probate court. It's may not have been emails, but it has been ongoing.
Can I go back to the two ones, your time is up, your time is run out.
Right.
You just saw a cover and you didn't open, there was an attachment, but you didn't open it?
I didn't see an attachment. I usually see a paper clip, and I quite frankly just saw 4 words that I would never have expected to get in an office email. And that's what I saw. And then 5 minutes later was the next one. My time is expired.
And where are those in the record? Do you have an appendix site by any chance?
I don't have it in front of me, Your Honor, but it isn't. They are in the exhibits.
The addendum to the appellee's brief,
yes,
pages 77 and 78.
Thank you.
Thank you.
One he did from his home and one he did from wherever he was working or a work computer. And he says that he filed a motion rule 56. I've never received anything, ever. He says he sent things or brought motions into the court. I've never received those either. How do I respond to something I've never seen?
Okay, so just you've got about 30 seconds left, maybe, if you want to conclude too.
Okay, I do.
I have a quick question. Did somebody CC'd in those 2 November emails whose initials are NA? Who is NA?
My paralegal.
Okay.
Okay. One more thing, Your Honor. I'd like you to look at the table of contents of his March 27th brief. Under the table of contents, number 2, Nancy Matz's false and fraudulent affidavit. That's not what the name of the thing is, but quickly. I'm sorry, I'm
Okay,
expired.
we will take a look at that. And so thank you both. We will, tough and interesting case, actually well argued by both of you, and we will take it under advisement.
We are live and on the record.
Okay, good afternoon and welcome to the last argument for this panel for the day. Actually, the panel's been slightly reconfigured. Judge Grant is not with us and Judge Wendlandt is in her place for this argument. As you know, the argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. We follow the same rules though and customs as in the physical courtroom, except that you may remain seated while you're speaking. Once we get going, the session clerk will display a countdown clock where her face was. At each side, it'll display 15 minutes and countdown. It does not turn yellow as in the courtroom. So each side gets 15 minutes. As usual, there's no rebuttal. Only one advocate will speak at a time. And in fact, the advocate who's not speaking will be muted when it is not your turn. This proceeding is being recorded and being archived. So it's available now for people watching and it will be available in the future on both on the Appeals Court website and on YouTube. As always, we've read your briefs and we're familiar with the case. Although you have 15 minutes, you're free not to use it all. We won't hold that against you. So with that, I'm going to call this last case, which is Commonwealth versus O'Donnell, 19P 1576. And Mr. Foley, you have the floor.
Thank you, Your Honor. Good afternoon, Your Honors. Thomas Foley for St. O'Donnell. This is one of those police identification cases where they identify somebody from a surveillance video, which we know they're not supposed to do. It was done here, but this is a little different because the prejudicial identification wasn't of the defendant. It was of somebody who wasn't even a part of the case, wasn't a co-defendant in the case. It was the alleged co-conspirator, the alleged joint venturer, Sarah Gordon. And that's what the Commonwealth really focused on in the trial. And there's a reason why I think the fact that the identification pertained to this, well, not unindicted, I think she was tried separately, but this somebody who was not a co-defendant, really wasn't even supposed to be a big part of this case, makes it even more prejudicial than if it had been the defendant who was identified. Now, they did identify the defendant, but not nearly as often, and it wasn't as prejudicial, and here's why. The jury knows that their job is to identify whether this defendant was the same guy in the photographs. And there are a lot of protections to make sure that they know that that's what they're there to do, and that's what they're going to do, and they're going to pay very close attention to that. There are jury instructions. That's the entire reason they're there. But when it's somebody who's not on trial, those same protections aren't there. And what happened in this case was it just came in that this woman was Sarah Gordon, but there was nobody that could identify her. Their identifying witness was excluded by the trial judge.
Can I just ask you one? I mean, this is very, it's an interesting argument. It's a very confusing sort of case. So let's setting aside the address on the photo, on the RMV photo for a second. Was it an error to admit the RMV photo of Sarah Gordon that says it's Sarah Gordon?
I don't think it should have been admitted, and I do think it was an error, but I don't think it was a very serious error that alone would rise to a substantial risk of a miscarriage of justice.
Right. I mean, so if you suppose you had just the picture of Sarah Gordon, and I mean, isn't it for the jury to try and figure out if this person in the RMV photo is the same person in the surveillance videos?
That's what should have happened in this case.
Right.
Yes.
But there's a few unobjected to. Did you compare Sarah Gordon's photo RMV to the surveillance photos, right?
There was that,
unobjected to.
And even more importantly was the prosecutor's opening statement, where she just comes right out 3 times and says, "This is Sarah Gordon" in the video.
Right, although that was prior to the motion to eliminate, right? So when she made that, Gallagher had not yet been prohibited from testifying at that point.
Boy, I should have gone back and looked at that, and I'm afraid I can't tell you
I'll tell you, it is. The motion to eliminate was not till the next day. So at that point, didn't the prosecutor have a good faith basis for saying that? If you assume that I'm right and that it hadn't been excluded yet?
Good faith basis. I mean, I'm not so concerned about whether the prosecution did this in good faith or bad faith. I'm just concerned with the prejudice to my client, and the prejudice, is undeniable. The jury was told right from the outset, this was Sarah Gordon, and did also in the opening identify or did also state that the police officer Maxon was going to identify from the surveillance video the defendant himself. So that was also done. But as I started out, that I could live with, because the jury is that's their job. They've got to compare the videos. But that didn't happen with Sarah Gordon. They were told right from the outset. And that's what makes the several police identifications during the testimony of Sarah Gordon even worse, because they've already been told it's Sarah Gordon, and now the police are saying it's Sarah Gordon. It just came in, this is Sarah Gordon. And in fact, the defense didn't even try to argue against it because it was just taken as fact.
Right. That's interesting. The defense didn't try to argue against it. Is there actually an argument that was sort of part of his defense strategy, that the police leapt to the conclusion that it was Sarah Gordon and therefore his client?
No, because the defense tried so hard to keep it out. The defense had the
no, he only tried to keep out.
The defendant tried to keep out the identification of Sarah Gordon, because I saw the motion in limine as trying to keep out the identification of the defendant, and the ruling of the judge was, Gallagher cannot testify based on a 5-minute viewing of the defendant 3 years ago, that in fact is the defendant. But I didn't see the judge saying anything to the effect of, you cannot identify Sarah Gordon.
I think at the beginning of that hearing, they were talking about the perpetrators, both of them, and they were discussing both of them. And the judge, it was the same ruling for both of them, because it was the same facts for both of them.
So if I look in the record, I'll find some motion that says exclude the identification of Sarah Gordon, not just of your client.
I don't know what the motion's going to say, but I don't think the judge ever put in writing what his findings were about.
Well, the transcript is,
the transcript is there, and the transcript, they're discussing certainly in the beginning. Now, by the end, I think they're talking a little bit more about the defendant, but the whole motion was about both of them. And I think the judge's reasoning, I think he was ruling regarding both of them. And why wouldn't he? Why would the police be allowed to identify Sarah Gordon?
Well, maybe because nobody said don't identify Sarah Gordon, and they just said don't identify the defendant.
Right, but I think if you read the beginning of that hearing, the defendant is arguing they can't identify both of them. The police shouldn't be allowed to identify both of them. So it comes in that, the prosecutor starts off, and the judge actually made a great observation. Is your whole case Detective Gallagher? And that's really what the Commonwealth was prepared to do. They thought they had an identification witness. But when they didn't, they had the opening statement when they identified not only the defendant and said the defendant was going to be identified by an officer, but they also 3 times said, this is Sarah Gordon. They could have just said, all right, everybody, here's Sarah Gordon. Now we got to find out who this other guy is. The danger, of course, was when the shared address evidence came in, because that provided the link. That showed the jury, well, this couldn't be a coincidence. We know this is Sarah Gordon, and we know she basically shares an address with Shane O'Donnell, and this could be Shane O'Donnell. I mean, I don't know about beyond a reasonable doubt that this is Shane O'Donnell, but when you throw in the shared address evidence, that allows the jury to say, well, this has got to be the guy then.
Well, so it seems like that's very probative. Why is it, and relevant, why is it inadmissible?
Because she shouldn't have been identified as Sarah Gordon. In fact, we still don't know if it's Sarah Gordon. I mean, they just said it was Sarah Gordon, but the only evidence we have is the prosecutor saying it, which is in evidence, and the police officers, comparisons. Why that came in after all the judge did in this case, with that voir dire that motion in limine. Why would he allow comparisons to come in also? It's the exact same effect.
And why wouldn't counsel object? Sorry, go ahead.
Yeah, counsel should have objected, and he didn't, and that's why I'm dealing with substantial risk, unfortunately, on just the identifications. But the counsel And I think also the counsel probably figured, if he thought about it at all, and I don't know if he did, but he probably figured, well, who cares if they think this is Sarah Gordon? There's no link. I don't think he realized that there was going to be a link, because I don't think he thought that address was coming in, because why would an address come in from somebody who hasn't been identified? And you know, if the jury had been told, if this was conditionally allowed in as evidence, if the jury had been told, well, you can't use this shared address evidence unless you find, I don't know, beyond a reasonable doubt, I don't know what the standard would be, but unless you find that this was Sarah Gordon, you can't use this shared address evidence. But they weren't told that. So I think it just came in, this is Sarah Gordon. The jury took it for granted. I don't think that was ever something they even thought about. The defense didn't argue it in the closing.
One of the things the defense did argue in the opening was calling into question the rush to judgment by the police, the lack of, you know, any other forensic evidence or tests being conducted. So I'm wondering why, in response, the prosecution cannot then say, all right, officer, tell us what you did do.
I think
like compare this photo to the RMV photo. Why is that not an adequate response?
Two reasons. First of all, case law, Commonwealth versus Wordsworth, which I think is the best case for you to look at. They conclude that the Commonwealth made the same argument in that case. They concluded the jurors had access to the video recording and could determine for themselves whether an officer, having reviewed it, acted appropriately in pursuing the defendant as the target in of the investigation. The officer's opinions that the individual in the recording was a definitive match to the defendant were neither pertinent nor necessary to rebut a Bowden defense. They specifically said that, the SJC and Wordsworth. It really doesn't, especially in this case, because what defense counsel was really arguing, when it came down to the using credit cards and receiving stolen property, it was all coming down to those photographs. But when it came down to who broke into those cars, the police had no evidence. They didn't have fingerprints. They didn't have videos from outside the gyms. The defense was arguing you can't convict him of breaking into these cars because there's no evidence of it, because the police didn't get fingerprints and they didn't get video from outside the gyms. The Bowden defense was really talking about those charges, and significantly, the jury acquitted him of those charges. They only convicted him of the charges that related to the video and the photographs, which is what my argument is dealing with. That's where all the prejudice was with the charges he was convicted of. The Bowden defense was going to the charges he was acquitted of, and the photographs had nothing to do with those charges. Other than you could argue, I suppose, well, since he used the credit cards, you can assume he was the guy that broke into the car. But, the jury disagreed with that, and I think defense counsel did a good job with that. So I don't think the Bowden defense gets the Commonwealth off in this case.
If the case had been tried without naming the woman, saying there's this woman, we'll redact her name, and did you compare the photos of that woman to the surveillance videos? Would you have an argument?
It wouldn't be nearly as strong at the very least. But that's why I started out by saying, the fact that it's not the defendant makes this an even more serious error, because there aren't those protections. The jury knows that they've got to review those photographs very carefully and compare those photographs themselves of the defendant and the guy in the video. But we don't know that they did that at all, because there was no instruction they had to do it. They were never told they had to do it. I think it was just taken for granted that this is Sarah Gordon. So.
And correct me if I'm wrong, I think the standard that they would actually have to use to determine whether it was Sarah Gordon or not would just be preponderance.
Even if it was just preponderance, just anything, so they had to make that determination, I think would have alleviated all or a lot of the prejudice, but that didn't happen. Well, Your Honor, certainly you seem to be following my argument very clearly. I think I've made the points. If you have any questions, I'm happy to answer them. Otherwise, I'd be happy to rest on my brief.
Any other questions? Okay, thank you. Thank you very much. We'll hear from the Commonwealth.
Good afternoon, and may
Go ahead.
Can you hear?
Yes.
Good afternoon, and may it please the court. Michael McGee for the Commonwealth. Counsel's argument focuses centrally on Ms. Gordon. What happened at trial here, unobjected to, is that the defendant's RMV photograph, numerous surveillance photographs were presented to the jury for their comparison. The officers were, and the prosecutor were very careful not to identify either the defendant or Miss Gordon throughout the trial. The judge was very careful to screen out Detective Gallagher. Counsel and I agree with that. It's a fact. He was not permitted to testify to the identification of the defendant. And that is Wordsworth. And the judge screened that out because he had no additional or particular knowledge of the defendant. Additionally, as was discussed, the one sentence about the video being good, the video evidence being good, was a proper response to Bowden evidence. And the prosecutor appropriately marshaled the evidence in this case, and asked the jury and invited the jury to decide that this was the defendant in the video, that he was working together with Miss Gordon as he was in the photographs with Miss Gordon at the Exxon, at the CVS, at the Shaws, and that the jury could see that with their own eyes and invited them to draw that conclusion.
Although, I mean, isn't it fair to say, and then problematic as well, that the way the case was tried, it was as if the Commonwealth knew, we know that this is Sarah Gordon in the videos. The only thing for you to determine is whether it's the defendant.
The fact that he used Sarah Gordon's name, and I'm speaking about the prosecutor at this point, as an argument is a perfectly appropriate argument to say that you have a certified RMV document that says this is Sarah Gordon, and that she is in a video, and he is not a witness. And I know that that, you know, is defense counsel's point, but he's marshaling the evidence. He's making the argument that she is in the video. But at the end of the day, and when we're talking about a substantial risk of a miscarriage of justice, the defendant's photograph and the defendant's certified record and all of these surveillance videos were also argued and also presented to the jury. And defense counsel avoids all of that. And that is what was presented to the jury. And that's why there was not a substantial risk of miscarriage of justice.
So you think even if we excise all the Sarah Gordon stuff, there's enough here, overwhelming evidence of this defendant's guilt?
There was photographs of the defendant at an Exxon looking right at the camera.
So you think the clarity of that was enough for the jury to say, yeah, that's him?
He was at the CVS with cameras 5 feet.
I know, but I thought the point of bringing in the Gordon stuff was to say, that's really clear. Mm-hmm. This is Gordon. And, you know, the two are linked. And the photos of the defendant are less clear, but they're linked. That you're saying that wasn't so important to the Commonwealth's case?
Well, there wasn't any error with the photographs. And I think we all agree that. If it was, and I don't believe there's
not the photographs, the actual saying this is Sarah Gordon.
He never said that. And, you know, it's not meant to.
The prosecutor certainly did.
But the evidence was in at that point, unobjected to, that Sarah Gordon, this woman in an RMV photograph, was in that. Well, it wasn't, that part of it wasn't in, but the surveillance was in, the RMV photographs were in, and it was numerous photographs of her and him together. There was a joint venture instruction about that. And it was appropriate for him to make that argument based on the evidence. And it was overwhelming. There was photographs and still photographs of them at the Shaws, the Exxon, the CVS together. And it was clear. And there was these RMV photographs that had their names on it. So it was perfectly appropriate for him to make that argument.
Now, if this had been a one-person operation, just the defendant, could the officers have
testified as they did testify with regard to Gordon? That is, could they have said, I compared the RMV photo of the defendant to the surveillance video?
If I understand the question correctly, if this was a one-person operation and it was just the defendant and Miss Gordon was not in any videos, I believe that as a offer of proof, it would be very difficult for the prosecutor to have persuaded the judge to speak about Miss Gordon, because it would leave the jurors.
Could the officers have testified, this was my investigation. I pulled the surveillance video, I pulled the RMV video of the defendant, and then I compared them.
Essentially what happened in this case was that, and it was appropriate, is that the steps that the police took to investigate this was appropriately before the jury, that he pulled surveillance tape, and I'm speaking of the detectives here, Maxon and Haslam, that they pulled the surveillance tape, that they pulled RMV photographs and compared them. They did not identify them, and that was screened out by the judge before trial. That is perfectly appropriate. It was for the prosecutor in his closing argument to make an argument about why the jury should believe that the defendant was in fact the person in that video. And I think that's perfectly appropriate. And there's no case law to suggest a prosecutor can't make that argument.
So just to repeat Judge Wendlandt's question, so it would be okay for the prosecutor to this line of questioning. Did you compare the RMV photo of the defendant to the surveillance videos?
That, I think, starts to get into what's going to be the answer. And the prosecutor in this case didn't do that. But
did it with respect to Sarah Gordon?
He did not. And all that they did was talk about the steps that they, and I apologize, Your Honor, I didn't mean to be, what I would suggest, Your Honor, is the record will show that the prosecutor laid out the steps that the police took to investigate this case. And a big part of defense counsel's case at trial was the steps that they took or didn't take. And the prosecutor here, even presenting his case in chief, laid out those steps, but was careful not to ask an identification question. Is that?
The question, actually, he said, did you identify? Oh, no, excuse me. Wait, did you compare? Is what he said, actually.
Right. And I can see Your Honor's,
I'm not saying there's any bad faith there, or I mean, there was no objection. The Commonwealth was trying to keep to the judge's ruling there, misspoke. But nonetheless, he did ask the officer, did you compare Sarah Gordon's photo to the surveillance photos?
Right.
He didn't ask you what did you conclude? He did stop short of saying what did you conclude?
And that's essentially my point, is there was no conclusion and no identification. Did I disappear?
Yeah.
There was no, that identification was not made. It was very careful about that. I believe I used the word scrupulously in my brief. And when a judge makes a ruling pre-trial with an experienced prosecutor about how the police cannot make an identification, they do act like this. They are careful not to ask that last question that would create an error. And there was not that in this case. They compared the photographs. He laid the foundation to put the evidence in and made his arguments in his closing arguments about why the jury should believe that the defendant was in these photographs. And unless there's other questions, I'll rest on my brief.
I think we get it. Very interesting case for both of you. Well briefed, well argued. Thank you. We'll take it under advisement. Thank you both. And so that concludes this argument and the session for today.